Happy New Year. Greetings to all of you.
Happy New Year. Happy New Year.
Yes.
My lord, may I have your lordship's kind leave to seek your lordship's leave to move this matter? This is not an SSC related matter, my lord. My lord, the urgency is in 2019, my lord. Petitioner was suspended. My lord, petitioner challenged the order of suspension. In the meantime, charge sheet was issued. Again, petitioner challenged, charge sheet set
So
aside
what is the urgency?
my lord, urgency is with the division bench directed in 2024 you complete the disciplinary proceedings within 6 months because it is pending charge sheet set aside. My lord, suddenly out of nowhere 2024 it was not completed. I filed the writ petition. It is pending before your lordship that allow me to join. Suddenly, my lord, without following any, without charge sheet, everything, they issued me a notice that you have been found guilty. What then? Now you will be terminated. Show cause. Why you will not be terminated?
That means show cause stage.
No, my lord. I have been found to be guilty. You have been found to be guilty only on the basis of punishment. What will be the punishment? Whether termination or not, that show cause. I have challenged that because, my lord, my writ petition.
All right. Give.
My lord, on Wednesday, my lord.
All right. Serve notice.
Yes, ma'am.
Urgent motion. Is it affirmed?
No, my lord. I am affirming and then.
Affirmed, then come.
My lord.
May I have your lordship's leave to move this? Some urgency is there, my lord. The petitioner was not a tainted candidate, my lord. Pursuant to the interim order of the Supreme Court, my lord, she applied for earlier service, my lord. But earlier authority issued the appointment letter. But before issuing appointment letter, she made prayer. She is lady teacher. She had 2 minor.
File it as the SLST matter. You file it in the department. It will come. The matters are going on. Hearing is
Identical
continuing.
issue, lordship have decided only. But I have annexed that.
Already decided.
Yes, my lord. Yeah.
Now it must be pending before the Supreme Court or the division bench.
No.
How
But
can it be
regarding-
that the court
regarding-
has passed order and appeal has
Sir,
not been filed?
regarding fresh posting, my lord, your lordship directed the
Fresh
Service
posting.
Commission, direct the service commission to ascertain a vacancy near her residence because she is a lady teacher. Her 2 minor child suffering from severe heart disease.
Yes. So what is to be done? All right, give.
My lord, I made prayer with
That-
naming the 7 schools where there are vacancies.
Well, that is the
My-
case I just told you. Can you remember that the maternity, pregnant lady?
That was different.
That is
That is absolutely
case only
different.
your lordship
This
have
is not a regular.
Your lordship in that case has decided, and we have also accepted that. And
No, exceptional cases is different.
we have
But I do not know.
It's also an exceptional case, my lord.
Let us see. Exception, not exception. Wednesday it will appear. Wednesday, serve notice.
My lord, may I be permitted to mention one matter? My lord,
Well,
it
can it be
pertains
on
to the
can it
second-
be on 6 instead of 7?
6 means Tuesday you want it.
Tuesday.
All right, Tuesday.
7th, I may not be here.
My lord, may I be
Tuesday means
permitted to
tomorrow.
mention matter?
Tuesday means
My lord,
tomorrow.
Today is Friday, sir.
Yes,
It's not Monday. We are mixing up things.
Sorry, my lord.
This matter pertains to second SLST, my lord. This writ petition has been filed by.
File it in the department, please.
My lord, it has already been filed. There was a direction for exchanging affidavits, but till date, affidavit has not been exchanged, my lord.
All right, let us see. Hearing is continuing. Let us see. There is no urgency as such.
My lord, kindly include this matter in the list.
It will appear in the list. If you have filed it monthly list, it will certainly appear.
I am seeking leave to move this matter urgently, but the issue involved in this matter, my lord, that the Respondent School Service Commission is not following their own rules regarding the 1:1.6 ratio, my lord, for calling up candidates.
File it in the department.
My lord, may I
File
file
it in
and
the department. It
then
will
give the number.
appear. It will appear.
My lord, I'm paying from upgradation. Few matters, my lord, petitioners are the job loser in respect of first SLST. My lord, petitioner want to repatriate in upper primary selection process. This order, my lord, covered your lordship's decision as well as division bench. My lord, 4 matter, they have participated in second SLST, but unfortunately, but qualified in upper.
That means first SLST, you had a chance. You went to some other school. Now you want repatriation. In the meantime, you participated in second SLST and you have been disqualified, not eligible.
And your lordship passed the similar order.
No, but then the stage is different. I do not know. Anyway,
My lord, stage is
anyway, you give the number. We'll see what is to be done. Upgradation.
My lord,
second SLST matter, my lord, is similar issue are directed to exchange the affidavit, my lord. In our computer application, my vacancy position has been minimum.
Whatever it is, you have filed it?
My
No,
lord,
don't give the number. It will appear.
it is listed. I'm paying for update.
Upgradation, wait. SLST matters are going on.
Subject to your lordship's kind sanction, I mentioned this matter, my lord, item number 256, my lord. The normal section teachers have been appointed and the academic section has been converted into upper primary section, and the issue has been decided by the honorable coordinate bench of this honorable court, despite that they are converting the academic section, and that's the issue, my lord. It's 5 minutes matter, 256. Any day your lordship may kindly take it up.
See,
Already
comments
decided.
will be published on Monday. So please come on Monday because upgrading today will not make any sense.
Not more than 5 minutes it will take because.
Come on Monday.
All right.
Same.
Come on Monday.
Then
Combined list
come on.
will be published.
For upgrade.
Correction.
Now corrections.
Lordship, it was passed. Lordship, I kindly. Lordship,
When was it passed?
order was passed on 19th November 2020.
What were you doing?
Lordship, it's a very minor correction. Lordship.
Maybe. What is the correction?
Lordship is just in paragraph 5. It has been recorded as deceased mother. It will be recorded as deceased mother. Only this much, Lordship.
My lord, may be permitted to mention one matter for contempt application, my lord.
No enlistment. Come on Monday.
Item number 284, to inadvertent mistake on the part of the department, it has come today. It is supposed to come on 6th.
All right.
So, my lord, kindly let this matter appear on 6th of.
Yes, yes. It will appear on.
284. No, otherwise, just a minute, just a minute. Otherwise, it will go in the monthly list, my lord. So let it appear in on 6th.
Assuming it goes in the monthly list, it can always appear on the next day
Yes,
also.
But we have served
Sorry.
notice accordingly, my lord.
All right.
That is the.
Inclusion, Lordship. May I be permitted?
Come on Monday, please.
Malad,
Yes,
restoration application, Malad.
Come on Monday. All inclusions on Monday.
So restoration application.
Inclusions on Monday.
Item number.
Yes.
Sir, request, my lord, before your lordship, my lord, when your lordship first have the determination, my lord, your lordship was taking up new motions, my lord. But now, my lord, your lordship has decided that new motions, if one filed a new motion, it will be posted in the next month.
Monthly list.
My lord, at least 2 weeks, my lord, then all this also mentioning and taking leave will also be, my lord, minimized. My lord, kindly consider, my lord, taking at least 3 days or 2 days of new motion, my lord, then if,
You save this quote from the second SLST matters. I'll take up all matters every day on regular basis.
my lord, it will be
Same-
over within few days,
Uh,
my lord.
Wait then. Nothing doing.
Lord, may
Yes.
I permitted to mention item number 250 for upgradation.
Come on Monday, please.
Lordship, for correction, Lordship.
What is the correction?
Lordship, the cost title, the name of the petitioner, the
When was the order passed?
17th November, Lord.
See, from November till January, you all waited. Give.
Lordship, similar matter, your lordship, my matter is new motion matter. The similar matter, your lordship passed the order to file the report, lordship. But my matter is appearing under the heading motion 1. Or all matter under the heading new motion are adjourned motion 1, lordship. I'm praying for only item number 62 and 63, similar matter, lordship. When this matter will be taken, lordship, I will be grant leave.
Mention, yes. Original side, please call.
But some money has been paid, but without any statement or without any particular.
Money has been paid.
All paid?
No, or nothing. We don't know all. There must be a statement backing the payment.
Very well, if you're
Otherwise,
I'll file a supplement affidavit of compliance, giving the
That's-
details of the calculation for that money, what we have refunded him.
This should have been done, Malad, at the first instance.
Been done.
Yes.
141.
Could have gone to the
Right.
department and inquired.
1 minute. Wow.
I have written to them.
141.
Yes.
10th of December 25.
Yes. After that, I write a letter that give me a statement. Nothing. I acknowledge payment receipt of
What
1
is
lakh.
this payment for?
This is the refund of-
Valuation brought down by the
Correct.
tribunal,
All right.
then accordingly
Then
he
the
went on.
valuation is quantified.
Yes. now
valuation is
according to
quantified,
that,
not
we
the
have
tax.
given.
Not the tax computed on basis of the valuation. And this they did not pay initially.
Right,
They
please
were
come.
trying to wriggle out of all this.
All right. Uh,
এটা নিয়ে আমি কি করবো?
the payment status for a sum of rupees 1,41,049 paid to the petitioner. In the month of December 2025. handed over in court today by the learned advocate representing the contemner is taken on record. Stop. Let the breakup of the payment be made known to the petitioner at the earliest. Stop. Released on.
After 26th.
Why?
Or I'll give a, my lord, affidavit of compliance where I'll give the details.
No, why? Why after 26? Today is just the second.
Second, yes.
Then
Keeps it after, because there is
I
nothing
want
left
to-
in this matter.
yes, exactly. That is the reason I want to finish it off. Why keep it pending
The
for
lordship
so long?
keeps it in the second week.
I'll keep it on the third week. All right.
I was just praying for that only.
19th, no, 26th goes to the fourth week. 19th of January.
Grateful, mother.
Obligement.
My lord, I appeal the petitioner. Lord, over here there is a direction by your lordship. Consider the representation. There is a dispute in pertains to the West Bengal Apartment Ownership Act. Now, my lord, after this, my lord, an order was passed. I just want to appraise your lordship regarding the order, my lord.
অর্ডারটা কোথায়? তোমার কমপ্লেন্সের কপি দিয়েছে? কমপ্লেন্সের কপি দিয়েছে তোমাকে? কমপ্লেন্সের কপি সার্ভিস করেছে? May I hand over the affidavit of compliance, my lord?
My lord, in this regard, my
28th of November.
28th of November, this
Yes.
order was passed and communicated to us, my lord. Now, my lord, in the second page of the order,
Yes.
your lordship be pleased to take, my lord, the observation. As per the available documents and the submission in hearing, it is found that many aberrations are there. So there is an opinion framed by the competent authority. There are certain aberrations. Out of all the aberrations, only one has been considered and taken up, my lord. Now, observing that, the summarized portion below that, in view of the above observation on the basis of
See, I see page 2 only.
my lord.
Certain directions have been passed. Right. A compliance report must be submitted. So the matter is disposed of with the special commissioner and the competent authorities taking steps. If you are aggrieved, file a writ petition. What remains in
Well,
the
the only
contempt?
thing is, my lord, two judgments in this regard, my lord. One is of our division, which was affirmed
Yes.
by the Supreme Court also, my lord.
Yes. What does it
Sir,
say?
what is the scope of the contempt, my lord? If your lordship be pleased to take paragraph 23 at page 6. My lord, whereby it was held, my lord, scope and object of the contempt proceeding is not only limited to impose punishment, my lord, but it has to be seen that the order has been complied in its true spirit. Now, the observation laid by your lordship in the writ petition is that all the points has to be kept open and considered in accordance with law. Now, what is in accordance with law? My grievance is that there are defaulters who are sitting at the management and running the board as of now. If there is a defaulter, they do not have the right to even go and exercise the voting right. Subsequent to those, they do not
Please
have.
come.
My lord, one
The order dated 28th November 2025, passed by the Special Commissioner and competent authority under the West Bengal Apartment Ownership Act 1972, filed by the learned advocate for the petitioner, and the affidavit of compliance filed by the contemner number 1.
Sole contempt, my lord.
All right, the contemner. By the learned advocate representing the contemner be retained with the records. Stop. It appears that the contemner has taken steps to comply the direction passed by the court. Stop. The order passed by the contemner is not no. The petitioner is aggrieved by the order passed by the contemner. Stop. I am afraid that in the contempt jurisdiction, the legality and validity of the order passed by the authority cannot be gone into. Stop. Next, in view of the above, the contempt application stands disposed of. Stop. It will be open for the petitioner to challenge the order passed by the contemner before the competent forum in accordance with law if so aggrieved.
My lord,
If so advised.
my lord, if your lordship so pleases, my lord, instead of petitioner, all the aggrieved persons, including the petitioner, because there are certain number of persons who are aggrieved by these orders. If your lordship is limiting the
Those persons are not in the contempt. They can always challenge it. No.
My lord, kindly record, my lord, the affidavit has already been handed over to him.
All right. Affidavit of compliance has been handed over to the learned advocate representing the petitioners in court today.
Great.
My lord, in this matter, Mr. Bari is appearing on behalf of the my lord, school authority.
My lordship, Mr. Anjan Bhattacharya representing the petitioner is unwell today, praying for not today.
It's Friday, that is why he's unwell. From Monday, he'll become well.
My lord, last occasion, your lordship was pleased to my lord, we have submitted before your lordship the in a maintainable point the same my lord, issue. My lord, de-getting school is pending before the honorable justice my lord, division bench. This is the president of the my lord,
Still now pending.
is pending. My lord, today is item number 16.
Very well. Accommodation has been sought for on behalf of the learned advocate representing the petitioner. Stop. Learned advocate representing the school submits that the issue as to whether the unapproved teacher of a DA-getting school would be entitled to the reliefs as sought for in the writ petition is pending consideration before the Honorable Division Bench. Stop. Next. In view of such submission, release the matter for further consideration on 19th of January. 2 weeks time. See what happens.
I am with you. 19th, sir.
So my application, my lord. Kindly see the last order of 2nd of December, my lord,
Yes.
passed by my lord.
Excuse me, sir,
in-
instead of 19th, kindly keep it on 20th.
20th.
20. Lordship.
I am appearing for the state in this.
Yes.
The petitioner seeks leave to file a supplementary affidavit. It is submitted that the documents to be relied upon by the people will be annexed in the supplementary affidavit. Let such supplementary affidavit be prepared and circulated prior to the adjourned date. This has been done, my lord. Today, if the permission is given, my lord, we can file the supplementary affidavit. And the last is if they were to file any
opposition,
they have to file it. My lord, they have been circulated, my lord, they have not filed. Now, this is of 9th of December, my lord.
That is supplementary.
Well, because I have annexed all the documents and my lord, the relevant laws, because their point is that the word unauthorized is there, unauthorized excavation. So it's illegal. I have shown, my lord, from the documents and from the law and from the circulars and from the rules that unauthorized doesn't mean illegal. It means that as against 1 rupee, you have to give 1.5 rupees as royalty. That's the simple point, my lord, one liner. Now, my lord, their first point was GST was not there. Can you recollect?
All right. Yes, respondent.
My lord, my learned senior is out of session due to the
Who's
sudden
your senior?
Brijin Pratap Singh, sir.
Yes.
Ma'am, due to the sudden demise of his cousin brother, he is out of station. So, my lord, kindly give any accommodation after Tuesday, my lord.
After Tuesday?
This Tuesday, my lord.
All right. Supplementary affidavit filed by the petitioner in court today is taken on record. Stop. Accommodation has been sought for on behalf of the learned advocate representing the contemners. In view of such submission, release the matter on 14th of January 2026.
Both the matters. Only one prayer, my lord. One thing, my lord, is very much sometimes.
One line. It will be open for the respondents to file affidavit in opposition to the supplementary affidavit prior to the adjourned date.
On 1st, that is yesterday, they have again sent us a letter. This is an everlasting thing.
In that case, see, continuously you'll go on filing
Absolutely.
supplementary.
So I am not praying for that. Only record, my lord. I have, because otherwise they may say I have suppressed this. They have said that
No suppression. They have issued it. You have received it. Next day we'll see what is to be done.
Very well, my lord. And both the contempt application, the writ petition, my lord, may appear together because we have prayed for, as I have indicated, my lord. That one line helps us, my lord. Kindly pass an order to that effect, my lord.
Both matters will list on
along with the contempt application.
Yes.
Deeply.
Much okay.
Lordship, I am for the secondary board, Lordship.
I saw everybody has received I undertaking file affidavit service.
Who is the answering respondent?
Answering respondent is going to be state and board both.
Board is here.
I beg to pay for the respondent number 11 and 12, my lord.
Private respondents.
No, my lord. School authority.
School. And state?
State presidency sticker.
Answering respondent also service commission, Lordship.
Central School Service Commission.
What happened, my lord?
Has commission been served?
Yes, my lord. Everybody has received, my lord. Everybody has received. My lord, what happened, my lord? The petitioner was appointed as assistant teacher in 2013 in a school at Habra, North 24 Pargana. 2021, he was transferred to Ramrik Institution, Bhavanipur, Kolkata. In the year 2023, after 2 years, since the petitioner was a surplus teacher, following the rationalization policy, the school education department again transferred the petitioner to a school at Boj. In the year 2023, he joined there, he was serving. After 2 years, suddenly in the year 2020-25, they have cancelled the transfer order and direct the petitioner to rejoin his earlier school at Ramrik Institution. In the Ramrik Institution, there is only 160 student and 19 teacher. Again, he will be a surplus teacher. And in the Bajbaj school, there are more than 1,000 students. There are only 22 teaching staffs. There are requirement of teaching staffs. Even thereafter, he was transferred. His transfer order was cancelled. The school authority made a representation. We have their requirement of teachers. Don't give effect and revert back the petitioner concern so that we can perform. Even thereafter, that was not been considered.
Cancellation.
Cancellation is at page on page 31. Page 31. And following that cancellation, further later in page 33, issued by the School Service Commission.
So this was in April 25.
Yes, my lord.
Have you
Yes, my lord.
joined the?
Yes, my lord. I joined. They said, you join there, we will consider. Even thereafter, they have not considered. Again, they will transfer. But only 160 students and 19 teachers.
Central School Service Commission, is anybody appearing?
Transfer
Show me your effective service.
Yes, I could not affirm. They all have. I could not affirm. All have received.
Sorry, order.
Sir, এখানে আছে।
Kindly take it on 6th.
Yes.
Kindly take it on 6th.
6th. Tuesday, come back. All right. The petition is agreed by the cancellation of his transfer order passed in the year 2023 and further directing the petitioner to revert to her earlier school is impugned in the instant writ petition. The petitioner has already joined the transferee school. Stop paragraph. None represents the West Bengal Central School Service Commission, the recommending authority for transfer. State.
Respondent number 11 and 12.
Stop next. The state is not represented either. Stop. Let further notice be served upon the non-appearing respondents. Stop. List on 6th. Yes. No issues. Serve.
My lord.
And check up from the GP's office. Did you?
Yes, my lord. I will serve notice. My lord. No, the state is not appearing. I serve the GP office of the government plate, my lord.
Check up. I do not see that slip.
My
हाँ,
My lord, I beg to appear on behalf of the petitioner in this matter. This is my affidavit of service.
This is
Prisoner of English.
prisoner of.
English or English?
May I please?
Yes, please.
My lord, petitioner belongs to OBC category.
Hmm.
And my lord, kindly come to page number 41.
Hmm.
Lordship will find she's Choitali Ghosh. She belongs to Goala Gop community. Now, my lord, kindly come to page number 41. Your lordship will find that serial number 4.
Hmm.
The heading is the category was list of other backward classes recognized by Government of West Bengal, notified till 3rd June 2025. Well, kindly see the heading more backward, category A. So Goala Gop was initially OBC B. She had the certificate of OBC B, but on 3rd June 2025, which was notified, Gazette notified on 10th of June 2025, which I have also annexed. My lord, this category, Goala Gop, has been converted to OBC A under more backward category. Initially, he had the OBC B certificate, my lord. Now, my lord, kindly come to page number 44 for once. I participated in the second SLST.
Yes.
My lord, kindly see the paragraph number 1. Having regard to orders which may be passed in special leave petition, diary number such and such, State of West Bengal versus Amal Chandra Das and others, filed in the Honorable Supreme Court of India, rising out of judgment and order dated such and such, my lord, I'm not placing, and connected writ petitions for the timing. Category details are not being collected and will be collected in due course prior to the applications being processed. It was the initial stage, my lord. Then second is that those who may have already submitted category details may be required to resubmit category details prior to such date. Applicants will be notified and link will be made available to submit and modify category details if required. So initially, my lord, category details were not collected. Accordingly, my lord, kindly come to the next page, page 45. My lord, kindly see, since category details were not collected, I applied as an OBC candidate. 500 rupees was taken. My lord, will not find any caste subcategory in the application. This is my initial application as permitted by the commission. Now, my lord, kindly come to page 47, where on 30th of July 2025, time was given from 5th of August to 11th of August. That was extended to 12th of August. For kindly take the second paragraph. The candidate will have to first log in and choose the edit option. Then she will have to select the category from the drop-down menu. The candidate will also have to specify his subcategory, the applicable certificate number and issuing authority in separate text boxes to be made available after the category is chosen from the drop-down if applicable. So I was given first time, my lord, I was given chance to apply, mention my subcategory here. Now, my lord, kindly come to page 48, which is very important. Paragraph number 2, serial number 2. 5th of August, the window was opened. 7th of August, this notification comes into effect. But kindly take serial number 2. I do not have a OBC certificate as yet, as I am a new entrant, not applicable to me. Now, next, my OBC category has changed. Kindly mark this. Or my certificate is an old and a manually issued one, or new certificate has not been issued. Well, I fall under this category. I already had OBC B certificate. I was converted to OBC A. New certificate had not been issued to me. So I come under this category. Now, my lord, kindly see the solution given by the commission. If you have an old certificate, enter that number for future reference and verification. So I was permitted to give the old reference number and certificate. If you are a new entrant and do not have a certificate, leave that field blank. It's not applicable. Now, this is very important as it is not a mandatory field in bold. Giving the subcategory was not a mandatory field. Why? It says it is made clear that actual physical verification of category details will be conducted only after publication of results of written examination. That means at the time of verification. So, Marat, from this paragraph 2, what we can understand that those who had already had the certificate got changed and did not receive the new certificate, they are allowed to give the old certificate number and the certificate because since it's not a mandatory field. Now, this is very important in my case. Now, my lord, kindly see the next page, page 49. According to this notification, I apply. Since I did not have the certificate, I had the old OBCB certificate. I mentioned myself as OBCB category candidate. Your lordship has found, my lord. The initial application, there was no category. Now, after this, I mentioned myself as OBCB since I had only the OBCB category certificate. Now, my lord, kindly come to page 53. That is the position. That is the merit position of the petitioner.
No, but then all these things happened when? All these things happened Long back.
No, no, no.
You are coming to the merit position after you see.
No, no, I'm not
what
coming. I have been converted to general. After 13th of, after filing the writ petition, this was issued, I was converted to general.
Yes.
That I'm coming to. My lord, kindly see just once. My lord, kindly see. This is OBC B. Kindly see at the heading. I was treated as OBC B. Kindly see OBC B.
Yes.
OBC B, male, female. Cutoff is 62. My rank is 5th. I got 65. OBC B, my lord.
OBC B.
B.
Cutoff is 62.
I got, kindly see serial number 5, rank number 5. I got 65. I qualify in OBC male, female.
Yes.
Kindly come to page 55.
Yes.
I even qualify for OBC A. Kindly see, this is OBC A, male female, cutoff is 61. Even if I'm not treated as OBC B, I'll be eligible in OBC A. The cutoff is 61. I got 65. Now, my lord, kindly come to page number 57. This is OBC female only. Here the cutoff is 59. I got 65. I qualify in 3 categories. Now, my lord, what happened? Kindly come to page 59 for once. I was treated as OBC B category, even at up to that point. Kindly see 59 called for verification.
Yes.
Throughout, I've been treated as OBC B. Now, my lord, kindly see this. After filing this writ petition, verification.
Why did you file the writ petition in the first place?
No, I was told that you will not be considered. You will not be considered as OBC A or B. You will be treated as general on the table itself. Now, it has reflected in this order. Kindly say I have been rejected on the same ground.
Page 59 was the verification date is mentioned is 4th of December 2025.
Yes, I went for verification.
OBC B.
OBC B. Now I was told that you will, by even documents were not even verified. I was told you will not be treated as OBC. You will be treated as general. But kindly see, it has been reflected. After filing the writ petition, my rejection has come with the same reason. Kindly see. Sir.
Not in cutoff due to category change.
Category change is general.
Current is general, total is 65 and cutoff is 66.
Now I've been converted to general where I miss out for 1 mark because I have not been treated as OBC. Now, my lord, I have also obtained the certificate now on 26th of December 2025. This OBC A certificate has been issued to me. May I just hand over? This is the new certificate I have received, my lord. Now, my lord, my humble submission before your lordship. First of all, my lord, OBC, it is by birth, my lord, I have acquired the status of OBC. Now, I was OBC B. As per the decision of the government, I have been converted to OBC A. So, even if I am not treated as OBC B or OBC A, in both ways, I am eligible. But the commission cannot treat me as a general category candidate and oust me from zone of consideration.
All right. Yes.
You had a certificate in Kuala.
In?
Kuala.
Huh.
Please study. It was earlier OBC 2.
B.
These certificates were cancelled by the commission. Then the new certificate. Now, in the new certificates, OBC page 34 kindly. Page 30. Koala, go transfer. With numbers transfer. Dated, transfer dated. These are OBC A. That will be clear from page 41.
Yes.
1. Category A. Now kindly come to me at page 43.
Yes.
Now see page 43. Serial number 90. Against serial number 90, short book. That is category B.
43. Page 43.
The certificate.
Serial number 90.
Short group.
Now, he has shown this document. I'm going to kindly come page 48, serial number 1. My OBC status has changed. Reading Labor Department notification number 10 June to what do I enter? My old OBC status or new OBC status? Answer: the status as per new subcategory details provided in the said notification and given in our drop down may by followed and OBC details filled up accordingly. Right. Then he should have given the voila is the reference, then it has come to OBC. What he did, kindly come to page 49. The category OBC B and then his subcategory subgroup. So we have proceeded with that here. That subcategory 2. I mean OBC 2. But at the time of the verification, he could not produce the certificate in respect of OBC 2, that's short form. His declaration. And that is the Miller kindly diagram of asset document. Miller kindly take this one. This document. 15 November. This is to notify all concerned that the preliminary interview list for class 11 and 12. So that's not very important now. 18 November. Kindly see last. It moment noted that candidates called for verification must bring all relevant documents, testimonial certificates to fully validate and justify whatsoever they have claimed during the online application. The commission fully reserves the right to reject the candidate if any application fails. Therefore, declaration is the OBC2, OBC3, Padgo. At the time of verification, he couldn't produce any documents. Therefore, he has to be gone to the general category, unreserved category. Kindly take this one, Mohit Kumar Jali, 2025 STC online. You want? Kindly come to me at paragraph 23. Sorry, 30, paragraph 30. But the first is similar, the paragraph 13 is different judgments have been quoted. Then kindly come to paragraph 14. What follows from the above decision is that irrespective of whether an aspirant for public employment belonging to a particular community like SC, ST, OBC, the status claimed by him for being accorded the benefit of reservation is per se not decisive. Such status has to be certified by the competent authority upon following due process and identification. Aspirant is what he claims to be. In Srinivas Prasad Shah, the requirement of production of a certificate from the competent authority was held to be mandatory in view of a statutory mandate. Although there is no such statutory mandate in fact, the requirement in question is no less mandatory and must be scrupulously followed. Once a process of recruitment is set in motion, all aspirants are entitled in law to equal treatment. There cannot be different yardsticks for different sets of aspirants. Non-compliance with the terms of the advertisement notification is bound to trigger adverse consequence of rejection of the aspirant's claim, stated by the selecting body and appointing authority, should he choose not to adhere to the same. Having regard thereto, the selecting body appointing authority would be justified in not entertaining the application of an aspirant as a member of the community for whom reservations are permissible. No, he claimed himself as Shodgo. He didn't show that document at the time of his argument. And that now everything is over. Interview, everything is over. In fact,
No, she was there in the interview.
I was there.
he was
Verification.
not in interview.
In fact, I was rejected.
It turned into the now I informed your lordship had passed. That day when your lordship was in the Jalpaiguri bench, that order was cited. Of course, in the civil custody,
Yes, and PH.
not only for the purpose of it, just a timeline had been fixed in case of SCS. And we have complied with that. There, Lord, I am informing you. And in terms of lordship order and the division bench order, 130% opted. I mean, in terms of the division bench order, they have been called in the interview, only 76% have appeared. Now, this week we have given a commitment to the Supreme Court that by 7th January we will publish the list of the 11th, 12th. Now, this week has to we have to continue this 76. We are in late period. We have to another 7 days. That we will stick to that. Now, therefore, anytime, every time, it cannot be. My prayer would be that everybody is coming. And here in the case that's for he has come. That's the reason I have said he is the prisoner of English.
Yes.
Yes, my lord. First of all, my lord, with deepest respect to my learned senior friend, that judgment refers to SC, ST, and PH. That has got no application in my case regarding OBC. First of the
division bench.
Division bench judgment. That is completely separate. Now, my lord, kindly come to page 48 for once. Paragraph 2, which clearly says, I do not have an OBC certificate as yet, as I am a new entrant, or my OBC category has changed. Now, or
Paragraph 1 also mentions about the change in the OBC category.
yes, I'm coming to that, my lord. I'm coming to that. Very well. Let us take paragraph 1 first. My OBC status has changed with new Labor Department notification dated 10th of June 2025. What do I enter, my old OBC status or new OBC status? The status as per new subcategory details provided in the said notifications and given in our drop-down menu may be followed and OBC details filled up accordingly. Now follows 2. It requires a number. The certificate number has to be put, which is written. Kindly see paragraph 2. I do not have an OBC certificate as yet, as I am a new entrant. My OBC category has changed, or my certificate is an old and a manual issued one. New certificate has not been issued. My lord, kindly see now. If you have an old certificate, enter that number. The number is needed for future reference and verification.
But then see, the issue they have raised is that you have mentioned or you have declared your subcategory as Shotgop.
That is how it has came. Because, yes, may I just kindly see, I was OBCB. I applied. First, there was no category. Kindly see, my lord. First, there was no category. If your lordship has seen paragraph page 45, there was no category. Yes, there was no category mentioned in page 45. It was not at the initial stage. Now, my lord, after this notification of page 48, I applied OBCB. Now, this subcategory came for clicking. I clicked. That is the only available GOP, short GOP. I belong to GOP, my lord. That came for marking.
This was page 49.
49, my lord.
This was
after page 48.
August.
Lordship.
August.
Yes.
Page 48 is 7th of August.
Yes, it is page 47th of August. Within 12th of August, we had to edit.
Right.
We edited. Now, this is the option came. We clicked, my lord, the short go. Now, my lord, my case is even if I am OBC A or OBC B, I qualify for both rounds.
1 minute.
Yes.
You did not have Shotgop certificate.
No, I had, my lord, page 33, Goala Gop. That is my initial
That falls in A. Goala Gop.
No, B initially.
Goala Gop initially fell in B.
B.
Right?
Yes.
Now you do not say Goala. You say Shodgop.
That is what I was given at the time of making application. That is what it was given to me. I had applied because OBCB, this is the subcategory.
Paragraph 15, kindly read this. You did not show that document before my lord when you were arguing. Now
Which
you are
document?
making
No.
Kindly read the paragraph 15.
Paragraph 15.
15. Kindly read the paragraph. After that, the category.
Yes, OBCB. Kindly see page.
B category can.
Yes, OBCB, a subcategory is Shodgo. Kindly see page 49. Kindly see page 49 category. That is OBCB itself. I did not mark myself OBCA or general. No, I always mark myself as OBCB because I had the OBCB certificate. I never had the OBCA certificate.
But OBCB does not contain the subcategory Shodgop.
OBCB contains Shodgop since it has been changed because GOP has been converted to OBCA. It was not given to me because 3rd of June, 10th of June, official notification, GOP Goala has been converted to OBCA. So it will not come under this subcategory classification. Now, when I apply OBCB.
Now also does this GOP and Goala fall in the same category?
Now means after 10th June.
Yes.
No, GOP Goala now OBCA. Kindly appreciate why GOP Goala did not come when I applied. Because by that time already GOP Goala was put under OBCA. So it will never come under OBCB. So I only got this Shodgop option. So I applied through this. Because it was not there. Because 10th of June it has already been changed to OBCA. Because when I mark OBCB, GOP will never come.
I do not know, Mr. Bandyopadhyay. The submission is that this option was not shown to the candidate.
Cannot come.
No. Kindly see, he has written this Shodgo.
No, he claims to be Shodgo.
One must know what is his class. Earlier it was Goala Go. Now he depends on Go. We are not saying.
What I'm sub.
Goala is still there.
Goala Gop is not there under. Sorry, I'm very sorry. Sir,
Page 33, you say Goala Gop. Yes. Now you claim to be Shodgop. How?
I tell you, Lordship. Goala Gop is no longer under OBCB since after
you
3rd June.
There in Goala. Whether Goala isn't there in A and B, it's not a matter. Thing is whether you are a Goala Gop or you are a Shodgop.
OBCB, my lord, may I clarify myself?
Page 33
yes,
is Goala
that's
Gop.
What my submission is. Goala Gop, may I clarify, my lord? Goala Gop was initially under OBCB. After 10th June, it got changed. After 10th June, I applied.
It got changed.
Goala Gop has been put under OBC A category.
Maybe, but right? You remain as Goala Gop.
I remain as a Goala Gop. Now, when I apply, when I apply OBCB, now this since it has been changed to OBC A, Goala Gop option never came. So only option under OBCB came as Shodgop. That I had to apply on
but
that.
Then you are not Shodgop. Then why did you mention it Shodgop?
Then she can never apply for any category. Kindly see.
This cannot be.
OBC B. I could not because I did not have the number and the certificate.
He wanted to take a more advantage.
No. OBC A is more advantageous. I qualify for OBC B and A both, but not for general. OBC B, my lord, this is the decision of the government. Because of the decision of the government, this situation has come up.
File their opposition. Will
my lord, I have made a representation. My lord, let them consider it, and
it will be
no, kindly
rejection of your representation.
Very well, my lord. Kindly give me 2 minutes. My lord.
Let them file their opposition. We'll see.
Only one
the
thing.
The petitioner participated in 2nd SLST, 2025 under the reserved category. Stop. She is aggrieved as the commission considered her candidature under the general category. Stop. According to the petitioner, she qualified under the category OBC A, OBC B and OBC female. But she is 1 mark short of the qualifying mark, not qualifying, cutoff mark in respect of the general category candidates. Stop. Paragraph. According to the petitioner, comma, her caste got changed. Her caste category.
Subcategory.
Subcategory got changed in view of the change made by the Labor Department. Stop. The petitioner initially declared herself to be a Goala Gop community candidate, but thereafter she disclosed herself to be the candidate of Shodgop category, subcategory. Stuff. Paragraph learned senior counsel representing the commission contends that the petitioner herself disclosed to be a member of the Shodgop subcategory, but she was unable to produce any certificate declaring her subcategory as Shodgop. Stop. She has accordingly been treated under the general category. Stop. Next. Whether the action of the commission in treating the candidate as not as under the general category has to be adjudicated. Stop. Let affidavit in opposition be prepared and circulated within a period of 3 weeks. Reply, if any, within a week thereafter. Stop. The candidature of the petitioner shall abide by the result of the writ petition.
Grateful, madam.
Take your documents
Went
back.
Yes.
Acha, it will be open for the petitioner to file reply to the opposition. বলে দিয়েছি তো 3-1 বলে দিয়েছি তো
3-1.
ঠিক আছে take this back, let the judgment remain. Affidavit of service
My lord,
written
liberty
with
be
the
granted
records.
to mention after the expiry of the time, since it's a recruitment. Let it be recorded, my lord.
3 weeks.
Very well, madam. I'm grateful to your lordship. Much obliged, your lord. If affidavit of service done. Grateful to your lordship.
Three, my lord, I am for the petitioner. I have served the respondents.
Yes.
This is the affidavit service. This is a matter relates to my lord. Petitioner, my lord, filed an application at page 17 for his higher studies.
School Service Commission.
No, School Service Commission is not the party.
I see here respondent number 3.
Three. We have served.
Who is the answering respondent? The state.
Respondent number state. Respondent number 5.
State.
DI.
Who is appearing? No idea.
First time appearing.
First time appearing. I make it not today. You inquire from the GP office who is there. It will appear under the same heading. Only not today.
Monday, my lord, monthly list, my lord. On the same.
What? Service টা ফেরত দিয়ে দিন
সার্ভিসটা দিয়ে দিন obliged, my lord. Grateful.
My lord, this is my application. My lord, I applied for, my lord, to make an application for modification of the order. My lord, last day I have been asked to serve once again to the state. My lord, in time I could not serve. That's why the GP office is not taking the receiving the service. My lord, online order is required to serve again. In the order, the subject has been mentioned physical education. It should have been biology. That is the order.
2007 matter.
2015 order passed. 2000, my lord, thereafter they took all the relevant documents. 2018 they disclosed that unless this order is modified, I cannot do anything. The DI's version.
2018.
2018. 2019 I made this application. 2015 order passed.
All right, serve and come back.
Your lordship's order is required.
Uh, this matter has been assigned before this bench by the Honorable Acting Chief Justice on 11th December 2025. The a connecting application has been filed in the year 2019. Stop, let a copy of the application be served upon the
Only DI is the responsible.
respondents. You choose upon who to serve. This is a madrasa matter.
Yes, higher scale of pay.
In a madrasa. Released on who appeared for the state in the earlier matter?
Earlier matter.
None appeared. There is no order as such. It only mentions that in case you make an application, the same will be
Whereas
considered.
in the first line
Yes.
of the order, the subject mentioned physical education and work education. First line in the order.
The petitioner was offered appointment as assistant teacher of work education under physical education.
That is wrong. That would be, my lord, biology, bioscience. That
assistant teacher of bioscience.
Yes.
Under physical. Show me the appointment letter.
Lordship. Appointment letter, approval, all I have annexed. Lordship, kindly come to page. Let us see. 30. Page 24 in the writ petition.
24 is, I have checked up page 24.
Lordship.
What does it say? The
The
board provisionally approves the appointment of the teachers who are not fully qualified or trained, subject to the condition that they will properly qualify themselves. Where is your appointment letter?
appointment letter.
Come prepared. No order.
Only service is required.
Service is also not required. You show me that you have a case first.
Lordship.
Only not today. Matter will remain in the list. In the same position.
Lordship.
Twelve.
I'm taking unconditional apology.
For what?
Actually, there was a direction of your lordship to deposit 5,000 rupees in the account of Bharat Foundation. What happened, my lord, with cash I went there, but with cash they do not receive it. And my check leave got exhausted.
Whatever you want, adjournment.
Adjournment for 2 days.
2 days.
Today I shall make endeavor 2 days.
On the prayer of the learned advocate representing the petitioner, hearing of the writ petition stands adjourned till 13th of January.
God bless.
Yes.
Your Lordship, I'm for the school authority. I'm praying for not today.
Not today. None appears on behalf of the petitioner. Stop. Learned advocate representing the school seeks adjournment. Stop. Adjourn for the day. Not today.
Your Lordship, appearing for the petitioner. Mr. Onish Roy is appearing in this matter. This matter pertains to non-granting of upgraded salary for period of January 2020 to February 2020, the 10 years benefit. The arrears have been given. Certain documents were sought for, we have supplied that. But the interest amount is still there. The interest amount on the arrear is still there.
Interest. Arrears have been paid.
Arrears have been paid.
And was there any direction for payment of interest?
There was any direction. Direction shall be interest period. There was direction. Your Lordship, 5% was there.
Where is it? Why are you inquiring from him? Why are you not prepared?
Your Lordship, he's the advocate on record.
Maybe the advocate on record. You are the arguing counsel.
Mr. Onish Roy is Your Lordship.
Whoever.
I am not very thorough with the read side, so I am a little bit of scared as well. In the last order of 13th November 2025, Your Lordship. Your Lordship, paragraph number 10. Order will be passed on the next date, it is said.
Order dated 13th of November.
13th November 2025.
13 November 2025, paragraph number 10. Necessary order will be passed on the next date. That means no order has been passed.
That will raise the next date, Your Lordship.
Right. You've received your arrears.
Received my arrears? Received, Your Lordship. Received my arrears.
Learned advocate representing the petitioner submits upon instruction that the arrears of the petitioner have been released. Stop. Prayer has been made for grant of interest. Stop. None appears on behalf of the respondents. Stop. Let notice be served upon the non-appearing respondents, intimating that the matter will appear in the list on 19th of January 2026. Stop. Parties shall come ready for answering the issue with regard to the interest which the petitioner prays for. Next.
Lordship, on behalf of Dr. Pal. Lordship, item number 15, I appear on behalf of the petitioner. Lordship, since I am not very well, I was asking for a day's adjournment so that I can appear before your Lordship physically.
All right, not today.
Lordship, may I pray that it be taken up sometime next Wednesday, so that in case I am not
on the prayer made on behalf of the learned advocate representing the petitioner, now by the learned advocate representing the petitioner, list on 7th.
15 and 16.
15 and
grateful,
16 both.
Extremely grateful to your
15
Lordship.
and 16.
There's only one thing, item 15 and 16, they're not connected matters. Issues involved are totally
Arising out of same selection process?
maybe, but totally different issues.
I don't think so. I'll be present.
I'll pass separate orders. This was there previously with recording. I do not know why.
Last similar order was recorded and this order matter was stacked.
I got said, it fell from the court that
We'll see it on the next day. Even if it is there in the list, it hardly matters.
very
Grateful to your Lordship.
17.
17, I am for the petitioner.
Yes.
Lord, the petitioner will obtain permission from the DI to enhance his postgraduate degree. Lord, the DI has granted permission, but the
where is the state? Where is the state? Ujani Pal Shamanto.
Samanto and my lord, the Mr. Bhaskar Vaishya.
I make it not today. Next day, please intimate her. 18.
18. I am for the statement.
My lord, a retired headmaster is before my lord.
Hmm.
My
Is the school council present?
lord,
Last occasion was appeared, madam.
Because the school was directed to pass on the details of Kajal Das so that you can implead.
my lord, they
Not
have
yet
not yet.
received.
I have not received. I have written 2 letters in my lord,
Okay.
reminding them.
Call him. Either I can pass it over or I can pass over for the day.
No, my lord, kindly, my lord, pass over for some time, my lord. There is some.
All right, I'm passing it over. You give a phone call.
My lord, I shall.
I don't know, 19.
এটা একটু pass over থাক 19.
19, I am for the state, madam.
Where is the petitioner?
I don't know. Sir is also here for the commission.
Commission was directed to revert with instruction as to whether the petitioner falls in the list of the tainted candidates published by the commission.
I have not received the instruction. Let it be not today. I'll come back on Monday.
All right, not today. Not today.
ঠিক আছে, not today. Not today.
Item number?
19.
20, I am for the
19.
petitioner.
Please record an order. 19. None appears for the petitioner. On the prayer of the learned counsel for the commission, release the matter on 5th. Yes.
My lord, 20, I am for the petitioner. My lord, here your lordship directed the respondents to come up with a report, my lord. This relates to, my lord, selection process of special educators. My lord, only filling up of form has been made, my lord. Nothing has commenced from
It
till
is
date.
being affirmed today. If it can be taken on Monday or any subsequent date.
If you affirm it today, then you have to serve a copy upon the petitioner, and then he has to file a reply or exception or whatever.
Yes.
So I adjourn it for the time being. What is the stage over there now?
There has been no development after the filling up of.
No
form.
development.
All right, please come. Learned advocate representing the commission submits that copy of the report will be served upon the learned advocate for the petitioner in the course of the day. Stop paragraph. It will be open for the petitioners to file exception to the report. How soon can you file the exception?
Within 1 week.
Within a week. Stop. List the matter for further consideration on 20th January 2026. Yes.
Item number 21, my lord. Petitioner is a special educator, my lord, and report have been filed.
Has been filed.
Report has been filed.
You want to file an exception?
But I can, but it's not, I think,
Required.
not required.
All right. Where is the report? Oh, report is already on record.
Himanshu Kayal.
Yes.
Well, petitioner is praying for age relaxation pursuant to the order passed by the Honorable Supreme Court of India. My lord, it's that page. May I just, your lordship has already seen, but still, my lord, I just kindly come to page 79. This is the point they have taken in exception. My lord, I was working from 2013 to 2021. Since 2011 to 2021. And my lord, 2021, I have left. So the in the month of December. So this discontinuance they are showing that this cannot be treated for the purpose of age relaxation. According to the School Service Commission, they are saying that if I continue till today, then only I will get age relaxation. But that was not the order of the Supreme Court. My lord, kindly come to page 79. The above portions, my lord, I just skip over, though they have taken in, they have tried to make one interpretation, particularly, my lord, page 78, if your lordship see. My lord, in the meanwhile, we have been informed that any of the states and the union territories, ad hoc teachers on contractual basis are presently imparting education and taking classes of children with the special needs. We have also seen, we have also been informed that in terms of the states, these teachers have been continuing for the last 20 years approximately. For these reasons, the states shall immediately constitute a screening committee consisting of the following. My lord, these were there. Then my lord, kindly come to page 79. My lord, second paragraph. My lord, the teachers, those who are working for that screening committee was made. Now, for the purpose of age relaxation, my lord, what the Supreme Court has stated, further, in case of a person who was already working and teaching for the last many years, the screening committee shall also be authorized to consider relaxation of the age limit in appropriate cases. So, my lord, who was working, so their age relaxation would be given. That is the, my lord, purpose of the, this is the one, only one, my lord, objection they have taken, that I was not working, I am not working now. I was working till 2021.
Till 2021.
Till 2021
And
December.
selection process commenced when?
But 25. I have
25.
approached the before this court on time. There is no, they have not taken this objection. হিমাংশু কয় এটাই একটাই তো অবজেকশন নেই কিছু
ওই সময় আয়ন ওয়ার্কিং মেইন জাজমেন্ট সেটা বলে দেন অক্টোবর 2021 এর
And my lord, the main judgment when it was passed at that point of time, my lord, I was working. October 2021. Eh, baba.
গেল রে দেওয়া আছে জজ সাহেবকে দেওয়া আছে কিন্তু মেন জাজমেন্টটা আগের দিন দেওয়া আছে
দেখেছি
Show me the recruitment. No, whatever is there in report, page 4, paragraph number 4, there is a recruitment notice, 21st of August 2025. Where is it? Page 4 of their report, paragraph number 4.
আমাদের রিপিটিশনের পেজ নাম্বারটা বল
48 to 58, my lord.
from the repetition.
No,
48 to 50.
21st is the judgment.
No. Recruitment notification.
যেটা চ্যালেঞ্জ করেছো
The recruitment notification which is under challenge.
Page
My lord,
87.
it's page, my lord, 81 is the rules and 87 is the notice. 87.
Is anything mentioned?
Relaxation.
My lord,
21st of August
rule contains the age relaxation part, not the notification, my lord. Notification is just for
Yes.
making application. My lord, rule.
Well, show me the rules also in that case, where there is provision for
82
relaxation.
82 page 82
80?
82.
82.
Rule 5.
Yes.
Minimum of 21 years and maximum 40 years on the first day of the year of advertisement. Upper age limit is relaxable for SC, ST, OBC and physically handicapped candidates as per state government norms, provided that the special educators are inclusive education for disabled coordinators of the state working under Paschim Bongo. Here they say working. Paschim Bongo, Samagro Shikha Mission and those who are working under government recognized special schools running under Mass Education Extension and Library Science Department to the Government of West Bengal with approval of the said mission or competent authority, district education officer, SSM of respective district in case of special education, that is i.e. coordinators working under Paschim Bongo Samagro Shikha Mission and district Mass Education and extension officer irrespective
May apply to the post up to 55 years.
after 55 years.
Right.
My lord,
And
they are saying who are working.
yes, all in all the places, Paschim Bongo Samagro Shiksha Mission, mass education, and then with the approval of such and such, working under such and such. That means who are still in service. They can
According to the
apply.
rules. But my lord, Supreme Court said who was in service.
Um,
Well, kindly see the Supreme Court order here. Page 79. Further, in case of a person who was already working. Well, this is a subsequent order. When the main judgment came, at that point of time, my lord, I was working.
you were?
I was working when the main judgment came.
Maybe.
But here the Supreme Court has clarified, page 79, who was working and teaching for the last many years. Page 79.
Yes. This is 7th March 2025. The rule is of January 2025. So the rule could not have contemplated as to what order the Supreme Court will pass. Right? So the order came later on. Supreme Court.
No, my lord, Supreme Court's judgment is
January and March.
7th March 2025, Supreme Court judgment.
And the notification of the state, that means the rules,
January 2020.
is in January.
January.
Right.
January.
So in January, the state will not know
No.
as to what order the Supreme Court will pass. In the earlier order, please show me.
The main order. It is already there, my lord.
Yes, Supreme Court order was in March.
The main order.
The main order was in 2021.
28th October 2021. My lord, kindly see.
That was the first order.
That is the main order. So at that point of time, I was working.
Yes. Does it mention anything about age relaxation over there?
No.
No, my lord.
No.
No. This is a subsequent clarification by the
All
Supreme.
right. The time to file the application possibly has expired.
Yes, my lord.
It has to be because the recruitment notice came in August 2025 and time was till September 2025.
My lord, I have filed the writ petition on time. My lord, kindly see my affirmation date of the writ petition.
16th September.
16th September. Immediately I have.
What's the position now?
Nothing, only form
Commission.
fill up, my lord. Nothing else have happened.
Only form fill up.
Only form fill up.
Commission. Can you consider the case of the petitioner relying on the 7th March 2025 decision of the Supreme Court? Because when the rules came, certainly there was no scope for granting any relaxation to the teachers who were already in service. That direction came in March. Your notice was though published in August, but it did not take into consideration the candidates who may have been working at one point of time, but then thereafter, for reasons, they could not work. That is continued service. Can you not reconsider relying on the Supreme Court judgment? I think you can.
Possibly, it will not be possible. Why I say this is like a break of service. You were working. What is the age relaxation for experience? You are out of touch since 2021. Your previous experience, maybe you were teaching. Then
you cannot lose your experience. One who has earned some experience.
Take the advantage. One is to be working.
Then now.
Of the appointment or the recommendation. That was the rule. Possibly Supreme Court, maybe it has used the term was working, but I do not think that the Supreme Court actually meant to interpret this rule and
not this rule, because this rule was not before the court.
Yes.
See the wordings of the Supreme Court, page 79. In case of a person who was already working, and teaching for the last many years. The screening committee shall be authorized to consider relaxation of age limit in appropriate cases. Not that for each and every candidate you have to relax the age. In appropriate cases, the experience
Understanding would be a candidate who is still working. In other situations also where relaxations or benefits have been given to candidates who are working, we have also taken clarification from the education department because they will provide. And in those matters, we have received the instruction that only if they are working on the date of recommendation, only then we have to consider.
If your submission is such, then this appropriate case will not fit in over here because you are generalizing.
No, I'm not. I'm accepting those who are still working. They are the appropriate cases. And those who have stopped working, chosen some other profession, gone into some other stream, they are not coming within the zone of an appropriate case. So we are rejecting.
May I add to this? Your ladyship, what has fallen from your ladyship is whether the commission can consider the petitioner's case. Your ladyship will kindly consider one thing, that the commission is bound by the rules, and since the rules have not contemplated taking into account the or giving the benefit to the case of the petitioner, probably, milady, the commission cannot go beyond the rules to consider the case of the petitioner. Point number one. Point number two is 2 and 3 go hand in hand. One is what the Supreme Court actually meant, and number two is clarity on this. Before I say this, let me point out that there is no declaration sought for against the rules. If it is the case of the petitioner that he suffers from the rules, or the rules are not consistent with the Supreme Court judgment or any other law, he must have prayed for a declaration. He has not. Only one mandamus has been prayed for from this court, that the court may be pleased to clarify. Now, the Supreme Court's order, if any clarification is needed, probably they need to approach the Supreme Court. They had this occasion in March 2025 already, because in January they were aware of what the rules are, and they are also supposed to be aware that the commission, being a recruiting agency, cannot go beyond those rules. They sat tight, unfortunately, in March till September, knowing fully well that his case is not going to be considered by the commission, because the commission cannot go beyond the rules. When they approach this honorable court, they have not sought for any declaration against the rules. And number three is, if they really want this clarification, they probably should have approached the Supreme Court even in September. And the point 3 I had mentioned before, your ladyship, is again at page 78 and 79. These matters came up before the Honorable Supreme Court with regard to state of Punjab and another state. However, it was later, this direction was made applicable to everybody throughout the nation. It was regarding recruitment of teachers or special educators in schools with regard to children in special needs. While giving all directions, at the last, in page 78, the Honorable Supreme Court has taken into consideration the case of the teachers who are working presently. Your ladyship has already gone through those sentences where the Honorable Supreme Court has been pleased to say that teachers on contractual basis are presently imparting education and taking classes of children. Meanwhile, we have been informed that in many of the states and union territories, teachers on contractual basis are presently imparting. So, all the direction which follows after this observation are made by the Honorable Supreme Court when it was informed that there are teachers. At that point of time, there were teachers who were already in service. For them, the Supreme Court has given two concessions. One is age relaxation. Another one is that the screening committee, etc., will look into their case of regularizing. So whatever direction follows from this will only be applicable to teachers who at that point of time at least were serving, if not today, at least on that point of time. So these clarifications are, firstly, to sum up, the petitioners knew as on January 2025 that their case is not going to be considered because the rules were very clear. They sat tight, they did not approach the Honorable Supreme Court. Even after the Honorable Supreme Court's order was passed, they did not approach the Supreme Court for clarification, what they want to be done over here, which is probably not possible. This Honorable Court probably will not clarify what has passed through the minds of the Honorable Supreme Court and what the Honorable Supreme Court actually meant. And number three, they sit back and then approach this honorable court belated at the month of September. That too without challenging any rule or without making out any ground therefore. So probably they are not entitled to any orders from this honorable court.
But I just give a reply to my learned
Yes.
friends here. My lord, the advertisement, my lord, it was not required for me
Once,
to.
may I just add only one thing before my learned friend starts? Page 79, that last paragraph which was taken into consideration by this honorable court. Further, in case of a person who was already working and teaching for the last many years, the screening committee shall also be authorized, there should be a two, to consider relaxation of the age limit in appropriate cases. So this inappropriate cases has been taken to be the appropriate case of presently working teachers. Again, I go back then to the same.
Already get it. Yes.
My lord, the advertisement, my lord, I was not required to challenge when the rule came into picture because my lord, advertisement clearly says, page 87, my lord, in compliance with the direction passed by the Honorable Supreme Court of India on 7/3/2025. That was the order. And now, my lord, just I go back to the order in respect of such and such cases. My lord, I just go back to the order.
Please read out page 78, the bold portion. Meanwhile.
In the meanwhile, my lord, may I just clarify? Meanwhile, we have been informed that in many of the states and union territories, ad hoc teachers or contractual basis are presently imparting education and taking classes of children with special needs. My lord, for them, the screening committee was made. And while, my lord, page 79, while Supreme Court granted age relaxation because this dispute did not crop up before, my lord, your lordship would find two words further in case of a person who was already working and teaching for the last many years. The screening committee shall also be authorized.
No, read out 78. Let us go serially. How Supreme Court went. 78.
78.
We have been informed that many of these states, ad hoc teachers on contractual basis are presently imparting education and taking classes. That means they are in service.
They are in service.
We have also been informed.
We have also
in
been.
some of these states, these teachers have been working for the last 20 years.
Hmm.
That means they are still continuing in service. Right? These states shall immediately constitute a screening committee. So the screening committee was meant for the teachers, ad hoc teachers on contractual basis.
Yes, they have been absorbed already. They have been absorbed already.
Possibly because of the Supreme Court's direction.
Yes, yes.
Right? Then you come to the next page, 79, first paragraph. The screening committee shall examine the case of each of the candidates who have been working on contract, daily wage basis to teach these children and found to be the past experience of these teachers shall also be kept in mind. Right? Then further, in case of a person who was already working and teaching for the last many years, the screening committee shall also be authorized to consider relaxation of age limit in appropriate cases.
This is a further category.
Right. Now, according to the commission, they are only considering the candidates who are still in service.
Still in service. Still in service, my lord, they have been absorbed. This is one category. Separate category.
How could they be absorbed?
Yes,
because the recruitment process started only by the notification.
They have been absorbed. In the Supreme Court order, it's there. Well, they have been absorbed. That is a separate.
What is the use of this order?
Well, this is a clarificatory order. This is a clarificatory order given by the Supreme. Recruitment is for the other persons, my lord. So, like categories like us. These persons, those who are already working, they have been absorbed. Well, that is why, my lord, Supreme Court says further in case of a person who was already working and teaching for the last.
I cannot understand because the recruitment notice mentions about this order.
This order.
Then how can it say that they are already?
No absorption.
Cannot be. See, they started.
Then why the Supreme Court has said it further in case of a person who was already working and teaching?
Right. Now, according to the commission, this appropriate case does not include your case. So if you want inclusion, then you have to go before the Supreme Court and seek for inclusion. What can this court do? This court cannot interpret Supreme Court's order in that manner.
Unfortunately for the
Well, it
petitioner,
is
the
not
case is still going on. Because as on, I have this update.
The case is still going on because the page 80 mentions about the next date.
Yes, no,
15th of July, then thereafter it must be continuing.
This has been taken up very recently also, because there was a question which crept up in the mind of the Supreme Court regarding whether TET is required or not.
TET, RCI qualification was sought for, then again TET.
Yes. Mr. Rana Mukherjee, learned senior counsel appearing for the state of Uttar Pradesh, has invited our attention to the judgment of this court in Rajneesh Kumar and has sought to impress upon us that teachers' eligibility test to be conducted by the appropriate government in accordance with the guidelines framed by the National Council for Teacher Education has been acknowledged as the minimum educational qualification for becoming an educator for classes preschool 5. This is absolutely contrary to the impression that we were carrying till date. And thereafter, NCT was directed to come up with the report, etc. I'm trying to find out the order. There is so date of the order. So many This was of 25th of November 2025. So I had taken.
And it is returnable on?
9 December or 12 December.
Then
2nd December.
2nd December.
Thereafter, I'll have to take up.
In case of a person who was already working and teaching for the last many years, the screening committee shall also be authorized to consider relaxation. Now, whether...
But my learned junior says that he knows for a fact this matter is
still going. All right. But then...
They can easily obtain this clarification from Supreme Court only.
Page 79, it will be very difficult for this court to interpret it in any other way. The screening committee, which was meant for the teachers who were imparting education, only by using the expression was, will it mean to include teachers?
Well, otherwise, the Supreme Court wouldn't have specified in this in a separate paragraph.
I can adjourn this. You go before the Supreme Court and obtain orders. I can keep it pending because they have not taken any steps in this matter. The recruitment process is still going on. And the date for filing the application is long over. So whether we hear it today, we hear it after 2 weeks or 3 weeks, it hardly matters. They are also not proceeding with the matter. I do not know why. Even though the matter is pending before the Supreme Court had fixed timelines, but still, for reasons best known, the process is kept pending. I do not know. And the number of special children in the state of West Bengal is quite high. It's 1,35,000.
Yes.
Compared to some of the other states, the figures reflected are quite high.
The order contains that.
Yes. So, why is the commission delaying in filling up the post of special educator? I do not know. I'll fix it for hearing in the month of March. In the meantime, you can take steps.
May I also point out one thing?
Yes.
That in any way, in absence of any challenge or any declaration prayed for against the rule.
A rule I have prayed for.
Probably not. So
yes, that is
they will not succeed in this matter.
Doesn't matter. If they can obtain order from the Supreme Court directly, then it will be better for them. Rejecting their prayer today and 2 months later, it hardly makes a difference to you.
Once they obtain a clarification, things will proceed very well.
Isn't it? Please come.
Very well. Oh, it is fixed on 13 January. But my junior has found out the order. চলে যাও অনেক সময় পেলে।
Had submission made on behalf of both the parties. Stop. The petitioner, how many are there?
One.
All right. The petitioner seeks benefit of age relaxation, relying on the order passed by the Honorable Supreme Court on 7th March 2025. In writ petition within bracket S, page 67, please take down. Civil numbers such and such in the matter of Rajnish Kumar Pandey and others versus Union of India and others, wherein the court permitted the screening committee to consider, not permitted but authorized the screening committee to consider age relaxation in respect of persons already working. Acha, Kurun, in respect of a person who was already working and teaching for the last many years as special educator for participating in the recruitment process initiated by the West Bengal Central School Service Commission with a recruitment notice dated 21st August 2025. Stop paragraph. It appears that the timeline for making the application for recruitment expired in September 2025.
But my lord, I have approached the court on time.
The writ petition was filed during the validity period for submission of the application. Stop paragraph. According to the West Bengal School Service Commission, bracket open, recruitment of persons for appointment to the posts of special education teachers, bracket close, rules 2024, published in the Gazette on 22nd January 2025, age relaxation is only permissible for the persons who are in service. Stop. The petitioner served as special educator from which date?
From 2011
From 22nd February 2011
till December 2021.
till December 2021. Stop. According to the commission, candidates who are still in service are only considered for age relaxation. Stop. Whether the petitioner no. It has been brought to the notice of the court that the matter of Rajnish Kumar Pandey, within brackets Supra, is still pending consideration before the Honorable Supreme Court. Stop. Paragraph. The hearing of the writ petition, the hearing of the writ petition stands adjourned till 6th March 2026. Stop. In the meantime, it will be open for the petitioner to approach the Honorable Supreme Court.
Pending.
Seeking clarification as to whether the petitioner may be granted the benefit of the second paragraph of page 13 of the order dated 17th March, not 17th, 7th March 2025. Stuff next. The let it remain. Yes.
Before your ladyship is pleased to take up the next matter with
1 minute. একটা line add up করুন তো. It has been brought to the notice of the court that the recruitment process has proceeded to the stage of filing the applications only. First stop. Yes.
with upon tendering apology, there was a mix-up in the previous matter. Mr. Dasgupta is already here. There was a direction on us to file a report in the form of affidavit that is ready. I thought it is for the next matter. So may I
File it. Give a copy to him.
Yes, sir, yes, definitely.
Our affidavit is also ready. I submitted it was being.
Yes.
Item 20.
Same matter. Item 20 take to আসুন তো. Has copy been served upon? Yes, both the copies?
Yes, now.
Now. কি বলেছিলাম 20?
ভালোই হলো তো। একদম
আমিও তাই ভাবছিলাম মেরে দিলে তো পেতাম।
একটাতে আছে একটাতে নেই, ও বলছে এটাতে নেই, তারপরে দেখছি আরে
আপনি ওই ফার্স্ট সেন্টেন্সটা রিপ্লেস করুন by mentioning the report filed by the commission and the state respondents in court today are taken on record. Stop. তারপরে লিস্ট অন এত তারিখে যেটা আছে এক্সেপশনটা থাকবে, ফার্স্ট সেন্টেন্সটা বাচ্চা। অল রাইট,
gratefully.
Well, I am for the petitioner. The deficit court fees have been paid in terms of your lordship direction within the time stipulated. Malad, a report was directed to be filed. Probably my learned friend is ready with the report. Ache, report?
did you get a copy?
No, not been given.
All right, let me see.
I could not affirm it.
Oh, could not affirm.
Well, it is a matter, Malad, special education, diploma in education, Malad, special education were not allowed to participate in the
Is it the same recruitment process?
Yes, just like the previous matter, but here the candidates have not filled up the forms.
Would not be filled up because we are not found eligible according to the notification.
They have done their self-assessment, that is a different thing.
That is there in the expressly, I am saying so.
Yes,
It is there.
but there was no filter in the online process. They could have put in their forms. Division bench has directed those who have not applied within the stipulated period, their cases.
But that order
Cannot be considered.
No. But that is not a.
All right, you give.
That is not an issue, Malad. Lordship, kindly come to page 30, 31st, page 30.
7 days time.
Yes.
Page 31st, Malad, Lordship will kindly come. We were not, Malad, even brought within the zone of
On the
consideration.
prayer of the learned advocate representing the commission, time to file the report stands extended till next Friday, 9th. No further. Exception.
Well, I don't think, Malad, exception will be maybe required.
All right.
Because 13th of November, they have decided to admit
List
such
matter on
person.
15th January 2026.
Yeah, we have already decided to take those persons who apply. আমাদেরটাও তো তুমি আর কি আছে কি তো প্রসেসে হয়নি প্রেজুডিস তো কিছু হয়নি এখন এফিডেভিট করার আগে কথা বলে না একই রকম করে গ্রেটফুল টু লর্ডশিপ নেক্সট ফ্রাইডে চল
And your Lordship's last order not will dated 2nd December 2025. This may bring
Whether part-time teachers of government-aided, government-sponsored schools.
whether
would
they are
be-
entitled to count their past teaching experience. That's the short question. And your Lordship had been pleased to direct the state respondents to obtain necessary instructions from the respective DIs as to whether the petitioners are serving against substantive posts or not. That's paragraph 6 of the order. And we had furnished to them the length of service rendered by each of the petitioners in the respective schools continuously, of course, and not till today they are continuing. And but we have furnished evidence to show that they are engaged as examiners and they are treated as persons holding substantive posts for the purpose of renewal of the subjects. So that's not where your Lordship wanted the instruction of the state to come forward.
Who's there for the state?
Lordship, I am appearing on behalf of the state, Lordship. Lordship,
Yes.
last occasion, Lordship directed the DI. DI made a party in this matter and directed to appear before his Lordship state. Here, Lordship, read petitioner is the Lordship 18 read petitioner. Here, Lordship mentioned in Kolkata district, but nobody is Lordship servicing in Kolkata. Here, 18 petitioner Lordship, 7 district is there Lordship. One is Jalpaiguri, Kuch Bihar, and Lordship Darjeeling. Fifth is the circuit bench jurisdiction Lordship. How many district Lordship I have collected the report Lordship? I have collected, my junior is here Lordship, 2 or 3 report I have collected Lordship.
2 or 3 report means in respect of 2 or 3
Three
candidates.
district, 2 or 3 district Lordship. If the Lordship directed me, then I will file it. But Lordship, only for the Kolkata district, there is no petitioner in Kolkata. 18 petitioners, 6 districts. Circuit bench or they are
I have
Lordship.
followed it. Yes. Are you there in Kolkata?
Kindly see the district Kolkata. Read petition Lordship.
জানাতে বলেছিল তো
DIs?
DIs of district এদেরকে
No, DI not made a party. Lordship directed.
Then Shiliguri, Jalpaiguri, Kuch Bihar, all of the circuit bench
Circuit bench
determination.
jurisdiction Lordship.
no part is not, some of them are here.
Who are here within the Kolkata jurisdiction?
Nobody. No 18 petitioner, no.
It says none.
7
None.
9
That means, see, the problem is
8 9 8 7 9 3.
they have to, the advocate has to obtain instruction from these DIs.
No, respondent.
8 is Kuch Bihar, 9 is Lordship Bardhaman, 7 is Lordship Kuch Bihar.
না petitioner না DI করবে আমি সেটা জানতে চাচ্ছি।
No DI Kolkata Lordship.
Where from are you getting this? Where the teacher, the school is mentioned or what? Where the petitioners are
The
teaching?
description is in the cause title.
Mentioned, school is mentioned Lordship.
School is mentioned.
No, school
Not in the cause title. The school's name is not mentioned in the cause title.
School is not mentioned. School is not mentioned.
Our difficulty is so Lordship.
To prepare a chart and hand it over to Mr.
That has
Kuch.
been handed over. That has been handed over.
Then he will require some time to obtain instruction.
But whole district Lordship, 9 district Lordship.
No.
You are representing the entire state.
No, Lordship. But district Lordship, when the read petition was heard for the only for the one district, not for the West Bengal.
No. But the main grievance is against SSC, of course.
The read
If the
petition is
Lordship
in respect
directed,
of
I
an
have no,
issue,
if the Lordship directed,
not in
Lordship.
respect of any particular district.
Lordship as per your Lordship.
Right. Please come. It has been brought to the notice of the court. And these petitioners are there? Not there. In your affidavit.
Lordship will kindly have a look at the report.
That's from page 25, 26.
Contractual teachers.
For working in substantive.
Right. That means you do not fall over here.
Please come to. No, that's the understanding of the state. Lordship will have to read this with the stand taken in the opposition. I mean the report.
Yes.
Paragraph 7 and 11.
Yes.
Thus, it is evident that for availing marks for teaching experience, a candidate should have rendered service in a substantive teaching post at the secondary level in a government-aided or government-sponsored school, either as a permanent teacher or on a contractual basis. So that's the understanding of the person affirming the affidavit or exception. Any candidate, not I shall try.
Wait, yes.
Let us not delve on this. Not any candidate
Just
who
wait,
did not,
yes.
any candidate who did not render service as a teacher in any substantive post is not entitled to receive marks for teaching experience. Not all teaching posts in a government or non-government or government-sponsored schools are substantive in nature. A substantive teaching post is a teaching post created in any government-sponsored or government-aided school with the prior approval of the competent authority, which in the instant case would be the government of West Bengal. Now please turn over to paragraph 11. It is stated that the writ petitioners at the time of filing the writ petition did not impede the schools where they have been purportedly taught, nor did they array the respective DIs who would certify as to whether the writ petitioners worked against a substantive post or not. Now that's why not your lordship passed the direction in paragraph 6 of your lordship's order.
If you already have a list, then what is the requirement of re-verifying it from the DI? 9 and 10 also. What is there?
It is stated that the
Yes.
answering respondents have received a list of teachers who have worked in substantive posts at secondary level in state government, aided and state government sponsored schools on a contractual basis. Such a list has been received by the answering respondent from the government of West Bengal, and the answering respondent would award marks for teaching experience to all those candidates whose names feature in such a list, provided such candidates filled in the requisite fields during the substantive of their application comes of the secondary school. Then we will annex. Okay, it is stated that the names of the petitioners do not feature in the list of substantive court. Secondary level government reading. Sponsored school on a contractual basis, not agency list petitioner advance any evidence along with the instant which will conclusively establish their service in a substantive post, and they thus cannot face it that the petitions are not entitled to any marks for teaching.
Right. So you are certain that the petitioners cannot be granted any marks on account of experience. Why did paragraph number 11 come in? As to where the DI will set.
That effort we have given it. That effort we have to give it. Statement DI has to say ultimately.
Then that means the DI has to say.
We have received the list. Therefore, list is the final determination factor.
You are taking contrary stand. Once you say the list provided is final, next you say no, the DI has to come to certify whether they are working or not.
That apart has to be said.
If that apart remains, then Mr. Boisho has to come in.
Yes.
Otherwise,
we will work on the basis of the state government instruction.
Obviously.
And the state government has given us a list.
Then there is no requirement of any further. Why has paragraph 11 been inserted?
If it is taken to extra written, it's all right, but the list is the final to us unless another list is provided.
That's right.
Please come.
That is given because of the non-joint development. And this type of petition, respectively, this type of petition is not maybe one for.
It has been brought to the notice of the court that the petitioners are teaching in various districts throughout the state. Stop. Learned counsel representing the state respondents seeks further time to obtain instruction from the respective district inspector of schools as to whether the petitioners are serving in any substantive post or not. Stop. Paragraph. The learned counsel representing the commission raises an objection with regard to the maintainability of the writ petition before the principal bench, as the schools where the petitioners are serving fall within the jurisdiction of the circuit bench at Jalpaiguri. Stop paragraph. As the issue as various issues relating to the second SLST, 2025 conducted by the West Bengal Central School Service Commission is being taken up for consideration in the principal bench, accordingly, let this matter also be retained in the principal bench. Stop. Learned advocate representing the state respondents shall obtain necessary instruction from the respective district inspector of schools relating to the service status of the petitioners. Released.
Lordship. As per your Lordship, 2 weeks?
19th.
Lordship, I am grateful.
Acha, 20th.
Lordship, grateful.
I'm for the petitioner.
You are for the
school authority. I'm praying for not today.
Why?
The pensionary matter, it was required to send the papers by 17, before 17. That has not been sent. And further order has been passed that 1,70,000 is required to be overdrawal amount. That is to be
provided.
Is to be given back.
Refunded.
Refunded.
By you.
By me.
All right.
And my lord, if your lordship goes through your lordship's order, previous order, my lord, para 5, 6, and 7, wherein DI was said that all necessary documents should be sent to for release of the PPO.
Your approval of appointment stood withdrawn.
They says, but I have now they says that everything is all right, but you have to pay 1,70,000.
Where they say everything is all right. I submitted the necessary document for. Oh, it is your letter. No, this is the school's letter.
Teacher in charge.
Approval for this reason, I submitted the necessary document for the overdrawn amount.
But says that is overdrawn amount. That is to be paid by me. But I have that judgment, my lord. My lord knows that Rafiq Masi's.
The papers have not been forwarded.
Not been forwarded.
Why? I'll make it only not today. Next day you come, but then be prepared. এটা ফেরত দিয়ে দিন তো, only not today. এই কাগজটা ফেরত দিন.
Only not today, my lord.
Yes, yes.
So Monday, my lord.
Monday.
Let it be Tuesday, my lord.
No, Monday it will be there. Doesn't matter, Monday it will be there.
My lord.
I am appearing on behalf of the petitioner. The last occasion, my lord, learned advocate general appear in this matter, my lord.
This is matter, virus challenge.
Yes, my lord. Whether it is the jurisdiction is sat or
I believe.
Mr. Vivekananda Bose was here just now.
Yes, Mr.
The AG is also not there. What to do?
Maybe,
Either call him,
yes, my lord, short password.
pass over. Next.
My lord, I am for the petitioner. Petitioner advocate is not there. He is out of station. I am praying for North.
Additional gratitude. Already has stated that he has got
He has got everything.
everything additional gratitude.
Additional gratuity he has got. Why did you pay additional?
The prayer. Submit to question. Lots of time see the page number 11.
Please take down. Accommodation has been sought for. On behalf of the learned advocate representing the petitioner, stop. Instruction forwarded by the District Inspector of Schools within bracket secondary education, comma, South 24 Parganas, dated 9th December 2025, mentioning that the revised gratuity amounting to rupees 6 lakh has already been paid to the petitioner. Be written with the record. Stop. Released the matter on 13th of January. Yes.
आप बता petition this matter.
Yes.
The pension matter वाला earlier occasion lordship was directed and in person
That
of the
is
lord
number 5 school. My lord, see, lordship's kind. Earlier order. Already board, I have got the documents from the board itself, school authority, that the
So
leave
already been-
period already sanctioned with pay.
with pay.
Now it is the task of the DPPG to issue pension payment order upon all
With pay.
with pay.
With pay.
That means it is in your favor.
Yes, that is. I have also my lord, checked it up.
Ah. Is the DPPG a party?
Yes, response number 4. I have checked it up.
Mr. Boisho, is he there? Please come. Learned advocate representing the school.
School, please add this to
Submit
my
upon instruction that the West Bengal Board of Secondary
board's
Education
also there.
video communication dated 11th December 2025 by the Deputy Secretary within bracket General of the board has communicated that the leave of the petitioner has been sanctioned with pay. Stop. Paragraph. The petitioner has he retired?
Retired long
Yeah.
back,
Oh, wow.
31st
31st
December 2001.
The petitioner retired from service on 31st of December 2001. Stop. He is yet to be released his terminal dues. Stop. Paragraph. The school authority is directed to forward all documents of the petitioner to the
Response number 4. No, we have 7 sent. DI also accepted, forwarded to the commissioner, page 29, 30.
And 17th of again communicate question. Then
Again communicate. Report আছে দেখি yes এই paragraph 4
report আছে গো
কি বললাম
একটা আছে
all documents of the petitioner including the communication dated 11th December 2025
I shall do this.
to the District Inspector of Schools for onward transmission to the DPPG for taking prompt necessary steps for disbursing the terminal dues of the petitioner. Stop. The matter is made returnable on 2nd March 2026. Stop. The respondent authorities shall ensure that the dues of the petitioner are actually disbursed prior to the adjourned date. Stop. Let this order be communicated to Mr. Bhaskar Prasad Boisho, learned advocate who usually represents DPPG before this court for necessary compliance.
Yes.
Instruction of the District Inspector of Schools, Secondary Education, Purva Mendipur. Signed on 23rd December 2025, be written with the record.
Under the same heading, my lord. Under the same.
Yes.
Under the same heading, to kindly recant. Otherwise, under the same heading, to kindly recant.
Right position, Lordship.
Lordship, I am for the secondary vote.
Okay, this is my last order. I am for the petition. Notun affidavit of service.
Lord, I have received the instructions from the DI South 24 Parganas. The instruction that I have is that my lord, the petitioner was initially appointed in the district of Purulia, where from the petitioner had my lord, went to avail the higher education qualification. And the communications with that school to the District Inspector of Schools, Purulia, but probably is needed for reference before your lordships, because I have the instruction to say that, my lord, the entire incident happened when the petitioner was posted at Purulia.
Sir, you are representing the state.
Yes.
Whether it is South
Lord,
24
I was just requesting your lordships. I was praying before your lordships that, my lord, let the district inspector of Purulia be added as a party here so that I can take instructions from him, my lord.
Please come.
Neither the erstwhile school is also not party here.
I'm praying for a leave so that I can do that. Also, my lord, my prayer before your lordship, this issue is, my lord, no more res integra.
Yes.
Because after, my lord, the several line of orders from this honorable court, my lord.
Learned advocate representing the state respondent.
May I have a report?
Submits upon instruction that that further instruction is required from the District Inspector of Schools within brackets Secondary Education Purulia for effective adjudication of the instant list. Stop paragraph. In view of such submission, leave is granted to the advocate on record of the petitioner to implead the District Inspector of Schools, Secondary Education Purulia, as party respondent in the instant writ petition. Stop. The formality of serving a copy of the writ petition upon the added respondent stands dispensed with, as the state is already represented by the learned counsel. Stop. Learned advocate representing the state shall obtain necessary instruction. Stop. Released on 19th of January.
Grateful. May I have a handover copy of the report?
And the report by the
District Inspector of Schools, South 24 Parganas, SE South 24 Parganas.
SE South 24 Parganas, signed on 8th December 2025. We written with the records.
Grateful.
But the affidavit of service, my lord, which have been, my lord, have formed on subsequent to your lord.
Yes, it has been written.
Lord, pursuant to your lordship's direction, report is here. PPO has been issued, pension has been granted, although shortfall of 6 months was there.
6 months is can be
Yes,
rectified.
your lordship.
What remains in the writ petition?
Kindly please.
Then since accommodation has been sought, what is to be done? Only not today. Keep these papers with you. So the next
Kindly
day.
keep it in record, my lord, otherwise here.
All right. Accommodation has been sought for on behalf of the learned advocate representing the petitioner. Stop. Learned Council representing the state relies on the instruction forwarded by the District Inspector of Schools within bracket SE Howrah, signed on 11th December 2025, and the revised PPO under ROPA 2009. No, don't write revised. And the PPO issued by the DPPG on 17th December 2025
And communicated to DI and petitioner also.
in favor of the petitioner be written with the records. Released on 7th January.
Deep level, I think.
Next. No. Somebody who's there, his name will be recorded. His or her. Yes. Yes. Where is your other side?
30 M for the petitioner. To
Yes.
the last order. I have also served upon the DI, Director of DPV.
State was represented by Mr. MP Chakraborty.
I have served upon all the respondents. After the order is passed.
But then give a phone call to your learned friend, or I make it not today. What? Not today?
Not today. It will be on Monday. Monday monthly list.
Doesn't matter. It will be there. Monday. Take the service back. And 31 also same?
No. 31 probably, as per the earlier orders, the old petitions which was pending, which was filed by her husband.
By the husband.
Husband died.
Let it remain. Let it remain. Actually, not today.
31 action.
Yes.
But she has been transferred to one of the school.
Lordship, the petitioner has a grievance with that as well, as it is the last school.
I do not know what the matter is about.
Your Lordship, it was regarding a transfer, Your Lordship. In the home district, the petitioner had given birth to a child in the month of July. Your Lordship, and the representation was also filed. Your Lordship had directed the SSC to consider that, and the SSC has considered, and the order has been passed. A recommendation has been given, Your Lordship. It is on 9th December 2025, but that is in an HS section school, which is the last school in the list which was provided on the last date. There was a list which was provided of the schools. A copy of the same was submitted, Your Lordship, to the learned senior advocate, Your Lordship.
All right.
Over there, the fourth school, which is a HS section school, over there she has been transferred.
And
but
you sought accommodation
for in a normal school, because Your Lordship, previous to 2016 when she was there, she was in a HS school. But previous to that, as per the order of the Honorable Supreme Court, she has to be repatriated into the previous post, not the previous school, but to the previous post. And she was in a normal section school. And there are 3 normal section schools where there is a vacancy of 1 Sanskrit teacher, which is nearest to her residence, Your Lordship, which was there in the list. The 4th school she has been transferred over there.
Let me see the list.
A copy text, sir, I got there.
এটা কি দিয়েছিল
ওই নিজের ওই লিস্টের মধ্যেই এই 4টে স্কুলের নাম ছিল।
এটা কোন পেজে আছে?
লিস্টের পেজ নাম্বার 3.
And this is
that school is even further from the school where she presently is. It is around 38 kilometers away. Presently, the school where she is, that is 35 kilometers away, as per the 2016 selection test. And the nearest school, all those are normal section schools, which was based upon normal sanction posts, Your Lordship.
See, I have this document where names of 4 schools are there. Right?
Your Lordship.
And you have been transferred
In the fourth school.
Paschim Narayanpur
Your Lordship, that is
School.
38 kilometers away.
Upper 8 kilometer distance.
And the other schools, Jo Tarapur, R.N. Roy Girls.
Lordship, over there, all the vacancy, one teacher vacancy is there. And
Still
those,
there?
yes, Your Lordship, it is still there.
28 kilometers, 7 kilometers. He said, yes, please.
My lord, we have, amongst the 4, list has been given. We have posted him within that.
Within that, in the farthest school, why?
Further is in our own district. That is in our own district.
Maybe
Earlier
the
it is.
district, this is the list of 4 schools.
Yes.
First school where there is vacancy, it is 7 kilometers away.
But this is he is saying vacancy. So we are not saying vacancy.
Your Lordship, kindly turn
No,
up
no,
to the
that
first
is all right.
school.
Then with that case, we will file an affidavit. We will deal with this matter.
No question of dealing.
No, my lord, he will be. Then he let him choose what school, or we have to
List of schools
construct
where
one school near to
vacancy-
our house.
A list of schools where vacancies are allegedly available has been handed over by the learned advocate for the petitioner to the learned commission for the commission, right? For taking. According to you, give me the list of schools where there are vacancies close to a
My lord,
residence.
whether it is within the judicial review.
Judicial review or not, the court.
No,
will
that's all right. No, then your lordship passes an order.
Yes, I'll
No,
pass order.
that is
Please come.
not that. It is not
Um,
that. We have to then construct one school near to in his area, in front of his house.
You have already constructed,
No,
which
no.
is 7 kilometers away.
Yes, 7 kilometers is all right. My lord, we have to see.
Right.
Now the point is this, my lord, not the vacancy.
The
Kindly, just excuse me, my lord.
the-
Kindly hear me. Kindly hear me for.
Yes, I have.
Just hear me, my lord. Hear me, my lord, just one minute.
Yes,
The
yes.
vacancy or is because of the arising out of the termination.
And the learned councils representing the petitioner and the commission has brought to the notice of the court that the petitioner has been posted at Paschim Narayanpur High School within bracket HS.
Recommended. We have recommended.
Achha, recommended for posting. Stop. Learned advocate for the petitioner submits that the school is 38 kilometers away from her residence. Stop. The petitioner has just given birth to a child. Stop. She prays for posting in a school where there is matching vacancy close to her residence. Stop. The list of schools where there are vacancies available for posting the petitioner was handed over by the learned advocate for the petitioner to the learned advocate for the commission. Stop. According to the commission, the school where the petitioner has been recommended for posting is in our home district. Stop paragraph. The commission is directed to
And also in matching vacancy, my lord.
and the commission is directed to produce the list of schools with matching vacancies close to the residence of the petitioner.
Which are vacant, my lord.
Stop.
Unless.
Next. Who's for the state over here?
Joyanto Samanto.
Joyanto Samanto and Indu Banerjee. Where are they? None are present. Acha. A list of schools with matching vacancies of the petitioner close to the residence, close to her residence, shall also be produced by the learned advocate representing the state respondents. Stop. The learned advocate for the petitioner is directed to communicate this order to the learned advocate representing the state respondents for compliance. Relist the matter on 14th of January. Will you be there?
14th, you are? Huh? Yes, 14th is all right. 14th is all right. My lord, kindly, my lord, that we will file an affidavit also.
File? You, it's your choice.
We will file an affidavit.
Your Lordship.
করা যাবে না
33.
There is a direction upon the CBI.
Lordship, I'm led by Mr. Arijit Majumdar. Learned DSGI and Mr. Arijit Majumdar both are out of station, Lordship. Kindly makes it not to be.
Yes. Get the report, my lord. If my lord wants, I
Which
can.
report?
In pursuance of my lord's order, my lord, they supply me a report, my lord.
All right.
Although that is
Since accommodation is placed, paid, I'll make it only not today.
Lordship.
All right. Tell them it will remain in the list.
Yes, Lordship.
All right.
মানে Tuesday.
Tuesday. 6 তারিখ 6. Listed
Tuesday, my lord, others matter is.
Other there?
I believe
I will not be here.
after 6, because 6 all that matter.
Let it remain in the list.
Yes,
If
yes.
it is taken up, fine. If not, then other
Yes,
will
yes,
be taken up. Call the passover matters. এটা 6 তারিখে হবে, লিস্টের নিচে লিখে দেবেন।
My lord, 18, Mr. Orunobo Ganguly is there for the school. My lord, due to some medical emergency, he is not there today. My lord, if kindly fix it on Tuesday. I have already provided them a limited amount of instruction that were directed by your by the court.
The 25th November, my lord directed that the alleged wife's name may not be particulars be
Details
furnished.
of Kajol Das. Did you
Yes, yeah,
when?
And here,
Just now.
we have
just now.
posted it.
Posted means?
Through GPO, your lordship. But
The council is present over here. Why will you go to the post office to post it?
well, it was being posted by the school itself.
You are not representing the school.
My lord, Mr. Orunobo Ganguly is there representing the school. But your lordship,
When will he come?
my lord, on Tuesday, if your lordship kindly fix it on Tuesday.
My lord, he has provided me with the details.
Yes.
My lord, I kindly, my lord,
Add.
permit me to add
Right.
and my lord serve notice on the added
Yes.
respondent.
Please
My
come.
lord, only one more thing. My lord knows that my lord, nomination, my lord, particulars are to be furnished by the incumbent. My lord, let the school, my lord, produce the document based on which, my lord, the headmaster included it. Because before the ADI, in the hearing, my lord, also the headmaster could not produce any document. So, my lord, he is playing truant. So kindly, my lord, direct him. I must have, my lord, given him the details of Kajoli Das, if she is my wife. Let him produce the document based on which he made the correction. My lord, kindly, my lord. My
You
lord,
are
kindly
the
take up my
teacher.
sub.
You are the teacher.
I am the teacher, my lord.
And
I have retired in 2023 February, my lord. I am, my lord, a bachelor. I am ailing. My lord, he has come, my lord, personally before my lord, to express, my lord, his apathy. But I said, my lord, to ask him to wait. He is, my lord, in.
Who is this Kajol Das?
My lord, Kajoli Das, my lord, was.
Kajoli or Kajol?
Kajoli.
No.
Lord Kajoli.
Kajoli, then it has gone down wrongly.
No, my lord,
That is there.
Lord, it is their version that she is Kajol Das. Now she filed, my lord, a
Now
petition.
something has to come whether Kajol and Kajoli is the same person.
No, my lord,
I don't know.
Now, my lord, this Kajoli Das, my lord, she filed, my lord, a petition, my lord, for under 125. That, my lord, got rejected.
And 498. 498.
My lord, got rejected. Now,
Ajay,
based
Ajay,
on that,
please
my lord,
come.
the headmaster has, my lord, now included it. Whatever.
Acha, details of the lady claiming to be the wife of the petitioner have been forwarded by the learned advocate representing the school to the learned advocate representing the petitioner. Stop. Let necessary let the lady be added as party respondent in the instant writ petition and a copy of the writ petition be served upon the added respondent. Stop. Release the matter for further consideration on 13th January 2026. Stop. Learned advocate representing the school shall produce documents relying on which the details of the lady got incorporated in the service records of the petitioner.
I'm grateful.
Your name will be recorded and not anybody who's not present. 25. Is the AG or Mr. Bose anybody here?
Yes. Yes. 20.
No, it's already 1:20, so no question of starting. Do we take up the matter?
Today.
At 2?
Yes, yes.
Yes, yes. I have spoken to the Learned Advocate General also.
Okay.
I appear for the
Well, I am appearing on behalf of the petitioner, my lord. My lord, in this matter, my lord, the juristic person challenge that this is the organization of the traditional school, government school, my lord.
Still now
Yes.
the tribunal is not functioning.
No. As per subject to correction, my lord.
Hmm.
So my first, because of the first day, my lord, Learned Advocate General pointed out that this writ petition is not maintainable before a single bench. But I can cite it 4 judgment, my lord, in this regard, my lord, and specific paragraph, my lord, in this regard. For judgment, first, my lord, start from L. Chandra Kumar.
Hmm.
L. Chandra Kumar. The Administrative Tribunal Act also.
Hmm.
But the State Administrative Tribunal is functioning since, my lord, in pursuance of the Administrative Tribunal Act 1985, my lord. Now, my lord, there is no such judicial member as well as the administrative member. Lord, I am citing the L. Chandra Kumar 1997 3 SCC 261 para 90 onwards. May place, my lord, para 90. Now start from para 89, my lord.
Somebody has placed this judgment of Sri Himadri De and others.
Yes, my lord, that is, my lord.
You placed it?
Yes,
The
yes,
petitioner placed it?
Yes, yes, yes.
All right.
Yes.
Has any order been passed in that matter?
Yes, yes. And
What?
the coordinate bench will also passed in other matter also.
Yes.
Somehow, because I inquired that
Yes.
whether the service jurisdiction usually, my lord, several writ petition is filed before a
And they
single
are taken up for consideration.
My lord, subject to correction, my lord.
Yes.
My lord, although there is a specific observation that the maintainability point is kept open,
Yes.
but the matter is taken up by the coordinate bench. Several matter. Well, I inquired from the council appear for the PSC, my lord. He says yes, several matter is my lord, pending before this High Court, my lord. Kindly turn, my lord, page number, sorry, para 90, 89 onwards.
Let me inquire once. AG, tell me one thing. What are happening to other matters? Tribunal is meant for service matters, right? The functioning of the tribunal is not going on regular basis, then what is happening?
Lord, there is no judicial or administrative member in the tribunal today. Therefore, Lord, there is a distinction between discharge of judicial functions by the tribunal and the tribunal functioning or not functioning. Tribunal has been set up, tribunal is functioning, but no judicial functions are being discharged. Therefore, what I had submitted on the first day is that they have to file a petition over there, get it registered, which means that the matter becomes sub judice before the tribunal. And once it becomes sub judice, in the absence of any member over there, the judicial consideration of that matter cannot take place. Therefore, one can come up under Article 226 or 227 before the division bench of our court and contend
Get
that
the things done.
yes, that was my submission.
But then the regular matters are being taken up by the single bench.
No, division bench. Division, it has to be.
Last occasion, I handed over the one order.
No, Milord, one thing is, Milord, the court takes up a matter without a point
Being
not
decided.
being raised. If it is raised, negated, of course, Milord, that may have some bearing, Milord, on this court. But I do not know which judgment my learned friend is referring
So
to.
it's an order. The point of maintainability was
Kept
raised, and it has been kept open, and the matter is
Otherwise, it was not decided.
not decided
Not
as yet.
decided.
Right.
But I'll, Milord, I'll tell your lordship the outline of my argument. My learned friend is placing L. Chandra Kumar definitely. Milord, with Article 323A and 323 being incorporated in the Constitution, Milord, the powers of the High Court under Article 227, 226
was obliterated. Then the question arose that is the judicial review power of the High Court taken away by Article 323A and B? But the Supreme Court says that it cannot be because judicial review is the basic structure of the Constitution. Therefore, the power of judicial review has been restored back, not restored back, in fact, it has been explained.
It remains.
It remains.
Right.
And since it remains, then what happens is where should the persons go? Supreme Court makes it a rule that you have to come before the High Court in a division bench. This is one situation. Contemplate another situation. Today, my lord, as your lordship is pondering, that since the tribunal is not functioning, or as my learned friend contends, a litigant can come before the division bench of the High Court. I am sorry, single bench of the High Court. I'm so sorry. When the single judge's determination is being invoked, the judicial review power of the High Court is being invoked. In a case, the single bench entertains, or L. Chandra Kumar principle is directly applied in single bench, not before the division bench. L. Chandra Kumar did not confer a right of appeal from a division bench order or intra-court appeal from a division bench order. It is one forum, first, as they call it, the court of first instance is the tribunal.
Appellate forum is the High Court.
Yes,
Division
not
bench.
appellate, since below Supreme Court uses the expression judicial review, I go by the Supreme
All right,
Court.
judicial review before the division bench.
Division bench. Now, once it is brought before the single judge, judicial review is brought before the single judge, then as per our latest patent, there is a right of appeal before the division bench. Whether that would run contrary to the intention of the Supreme Court to restore the power of judicial review by L. Chandra Kumar. Please consider that. That would be, Milord. These are the outlines of my argument. I'll develop that. That is why, in my humble understanding, Milord, my learned friend definitely can come before the High Court at the first instance in this kind of a stalemate condition, but not before the single judge, but before the division bench.
Why is the stalemate condition not being taken care of?
Milord, I'll tell you, Lord, I had tried in my own way because I was invited in that committee. I thought that Advocate General cannot be part of that committee because the statute does not provide. Unless, of course, where the Supreme Court gives any direction, that is a different aspect. But the problem which arose is that, Milord, the committee should comprise of inter alia the outgoing chairman. Now the process was started so late, by that time Justice Pal had retired. Gone. Therefore, I requested the Chief Justice that if you can invite me, why not Justice Pal? Then the Chief Justice agreed. Then I called up Justice Pal. His Lordship was gracious enough to accept it. Then, of course, he was included. I stood out. Advertisements were published. Some of the honorable judges have applied. Twice application was, advertisements were
No
published.
suitable candidate found or what?
I have lost track because for me to gather information is difficult unless something comes to me.
No problem is, see, the petitioner is not the only litigant.
Right.
Tribunal is an institution on its own, has its own act, own functions and everything. Where will the litigants go?
Right. But these are all
And
I quite appreciate.
relegating the petitioners or the litigants to touch the tribunal and come here means
that means I will
another extra forum.
lose a forum.
Another extra forum is being invoked,
And
isn't it?
specifically give answer. I'll place the judgment. I believe I am very much grateful to learned Advocate General because he gave the outline of his argument.
Yes,
I will try to.
You know what to address.
Yes. Kindly take them now, Malad. I just I reduce another paragraph, Malad, para 90 onwards, Malad, and specifically para 93, and thereafter I will refer Malad Walpole. Thereafter, I will refer the Magad Sugar. And what is the consistent stand of the Supreme Court before L. Chandra Kumar and after L. Chandra Kumar? I will place. I start from para 90. We may first address the issue of exclusion of the power of judicial review of the High Court. We have already held that in respect of the power of judicial review, the jurisdiction of the High Court under Article 226 of the High Court under Article 226, 227 cannot wholly be excluded. It has been contended before us that the tribunal should not be allowed to adjudicate upon matter where the virus of the legislator is questioned, and that they should restrict themselves to the handling matter where constitutional issues are not raised. We cannot bring ourselves to agree to the proposition as that may result in splitting up proceedings and may cause avoidable delay. If such a view were to be adopted, it would be open for the litigant to raise constitutional issue, many of which may be quite frivolous, to directly approach the High Court and thus subvert the jurisdiction of the tribunal. Moreover, even in these special branches of law, some areas do involve the consideration of the constitutional question on a regular basis. For instance, in service law matter, a large majority of cases involve an interpretation of Article 14, 15, and 16 of the Constitution. To hold that tribunal have no power to handle matter involving constitutional issue would not serve the purpose for which they were constituted. On the other hand, to hold that all such decision will be subject to the jurisdiction of the High Court under Article 226, 227 of the Constitution before a division bench of the High Court within whose territorial jurisdiction the tribunal concerned fall will serve two purposes. While saving the power of judicial review, the legislative action vested in the High Court under Article 226, 227 of the Constitution, it will ensure that the frivolous claims are filtered out through the process of adjudication in the tribunal. So that is a filtration process. The High Court will also have the benefit of a reasoned decision on merit which will be used to it in finally deciding the matter. Now paragraph 91, the specific paragraph is paragraph 93. I just give the background of it. It has also been contended before us that even in dealing with cases which are properly before the tribunal, the matter in which justice is dispensed by them leaves much to be desired. Moreover, the remedy provided in the parent statute by way of an appeal by special leave under Article 136 of the Constitution is too costly and inaccessible for it to be a real and effective. Furthermore, the result of the providing such remedy is that the docket of the Supreme Court is crowded with the decision of tribunal that are challenged on relatively trivial ground, and it is forced to perform the role of a first appellate court. We have already emphasized the necessity for ensuring the High Court are able to exercise judicial superintendence over the decision of the tribunal under Article 227 of the Constitution. In R.K. Jain case, after taking note of this fact, it was suggested that the possibility of an appeal from the tribunal on question of law to a division bench of High Court, within whose territorial jurisdiction the tribunal falls, be pursued. It appears that no follow-up action has been taken pursuant to the suggestion. Such a measure would have improved matter considerably. Having regard to both the aforesaid contention, we hold that all decision of tribunal, whether created pursuant to Article 323A or Article 323B of the Constitution, will be subject to the High Court writ jurisdiction under Article 226 oblique 227 of the Constitution before a division bench of the High Court within whose territorial jurisdiction of the particular tribunal falls. And I stop here, my lord. Thereafter, my lord, next two paragraphs is very important. Supreme Court observation is that after tribunal, division bench is the usual course of the action. They can challenge it. 92, my lord. We may add, now adding, we may add here that under existing system, direct appeals have been provided from the decision of all tribunal to the Supreme Court under Article 136 of the Constitution. In view of our above mentioned observation, this situation will also stand modified in view that we have taken no appeal from the decision of the tribunal will directly lie before the Supreme Court under Article 136 of the Constitution, but instead the aggrieved party will be entitled to move the High Court under Article 226 oblique 227 of the Constitution from the decision of the division bench of the High Court. Aggrieved party could move this court under Article 136 of the Constitution. But this is 136. Now, my lord, very next paragraph, that is most important. Before moving on to other aspects, we may summarize our conclusion on the jurisdictional power of this tribunal. The tribunals are competent to hear matter where the virus of the statute provision are questioned. However, in discharging this duty, they cannot act as substitute for the High Court and the Supreme Court, which have under our constitutional setup been specifically entrusted with such an obligation. Their function in this respect is only supplementary. Here, my lord, my case is that, my lord, I challenge the constitutionality of a specific state act. Here, my lord, the Supreme Court observation is that the tribunal function is supplementary to the High Court. I read it again, my lord. Their function in this respect is only supplementary, and all such decision of the tribunal will be subject to the scrutiny before the division bench of the respective high courts. So, my lord, high tribunal power is supplementary to the High Court.
What is the challenge here?
My lord, State Act is challenged. Rule, sorry. Page 81, my lord. That is, this rule may be called the Assistant Master Mistress Recruitment Rules 2024 in Government High School, Government Model School, Government Integrated School, and National Integrated Government School under Backward and Grant Fund Scheme in the West Bengal Subordinate Education Service under School Education Department, Government of West Bengal, excluding the Assistant Master Mistress in Physical Education. Well, what they did, Malad, by the dint of this rule, they clubbed a scheme with a traditional government school teacher, which is not permissible. Along with added, they're clubbing the three types of school. One is school under BRGF scheme, the traditional school like Hindu school, hair school. They want to transfer the teacher from that BRGF school to the traditional government school, which is not at all permissible. I will place the letter on, because for that I will satisfy this court regarding the jurisdictional point. Where I place the 93, thereafter I go to the Whirlpool, thereafter I go to the Mughal Sugar Mill. The tribunal will be subject to the scrutiny before a division bench of the respective High Court. The tribunal will consequently also have the power to test the virus of the subordinate legislation and rules, but very specific. However, this power of the tribunal will be subject to one important exception. The tribunal shall not entertain any question regarding that is their own statute, so nobody can be judged of his own court. So that is their, my lord. Now, my lord, after that, my lord, kindly take Whirlpool to the Whirlpool Corporation. 1998, 883, page 1. Para 14 onward. After L. Chandra Kumar, my lord. What? 19. Para 14 onward. The power, para 14. The power to issue prerogative writs under Article 226 of the Constitution is plenary in nature and is not limited by any other provision of the Constitution. This power can be exercised by the High Court not only for issuing writ in the nature of habeas corpus, mandamus, prohibition, coherent, and certiorari for the enforcement of any of the fundamental rights contained in Part 3 of the Constitution, but also for any other purpose. 15. Under Article 226 of the Constitution, the High Court, having regard to the fact of the case, has to discretion to entertain or not to entertain a writ petition, but the High Court has imposed upon itself certain restriction, one of which is that if an effective and efficacious remedy is available, the High Court would not normally exercise its jurisdiction. But the alternative remedy has been consistently held by this court not to operate as a bar in at least three contingencies, namely where the writ petition has been filed for the enforcement of any of the fundamental right, or where there has been a violation of principle of natural justice, or where the order of proceedings are wholly without jurisdiction, or the next or is very important, or the virus of an act is challenged. So, my lord, if I got it, the virus of act is challenged, then High Court have that plenary power under Article 226. That is para 15, my lord. There is a plethora of case law on this point, but to cut down this circle of forensic whirlpool, we would rely on some old decision of the evolutionary era of the constitutional law as they still hold the field. Now, my lord, thereafter some case law is cited. I just keep it over, my lord. Now, my lord, para 20. Because it is well settled law. Para 20. Much water has since flown under the bridge, but there has been no corrosive effect on this decision, which, though old, continue to hold the field, with the result that law as to jurisdiction of the High Court in entertaining a writ petition under Article 226 of the Constitution in spite of the alternative statutory remedies is not affected, specifically in case where the authority against whom the writ is filed is shown to have had no jurisdiction or had purported to usurp jurisdiction without any legal foundation. Here, my lord, the state action is under challenge. Here, two state action is under challenge. One is that, my lord, the state made a rule which is under challenge by the dint of this writ petition, and the state not give appointment any judicial member as well as the administrative member. So state wants not want to scrutinize their act, whether in the way of legislative act or administrative act. For that reason, the state not appoint, my case is that, my lord, state not appoint any judicial member as well as the administrative member.
Have
And
you made
another
out-
thing,
Have you made out that?
no, not specifically made out, but that is action is to do so, because there is the legal question is involved in this matter, my lord. Second thing is that, my lord, kindly visualize one thing. If normal courses, I got 3 layered. One is that court of the way of court of first instance, I got the tribunal. Thereafter, the way of judicial review, I got the division bench. Thereafter, Supreme Court. If the state not appoint any judicial member or administrative member, that means a petitioner, my lord, he lose a very important, my lord, forum. So, my lord, the petitioner lose a forum by the dint of the State Act. And I challenge here by this petition, my lord, state action, legislative action, my lord. So, my lord, state consciously, not by not giving the appointment of the judicial member, they deny the right of the petitioner, my lord. Third, my lord, Magod sugar. Very specific paragraph, my lord. I will not take more time. 2022-16 SCC 428 para 20. Para 20. 2022 SCC 428. Para 20. Here, my Supreme Court specifically narrated when the High Court will exercise its jurisdiction. While a High Court would normally not exercise its jurisdiction under Article 226 of the Constitution if an effective and efficacious alternative remedy is available. Here, my lord, alternative remedy is not available. The exercise of an alternative remedy does not by itself bar the High Court from exercising its jurisdiction in certain contingencies. This principle has been crystallized by this court in Whirlpool Corporation versus Register of Trademark, and such case law is mentioned at 2 judges bench of this High Court, my lord. This court has observed. Now, my lord, the court observation is very. The principle of law which emerge are that the power under Article 226 of the Constitution to issue writ can be exercised not only for the enforcement of the fundamental right, but for any other purpose as well. That is in Whirlpool, that is mentioned, my lord. The High Court has the discretion not to entertain a writ petition on of the restriction placed on the power of the High Court is where an effective alternative remedy is available to the aggrieved person. But here, my lord, Supreme Court in L. Chandra Kumar, para 93 says that is a supplementary power. Tribunal power is the supplementary power. Now, my lord, 27.3. Exception to the rule of alternative remedy arise where The writ petition has been filed for the enforcement of a fundamental right protected by Part 3 of the Constitution. There has been a violation of principle of natural justice. The order or proceedings are wholly or without jurisdiction. The virus of a legislation is challenged. Here, my lord, virus of the legislation is challenged. Not says that this particular virus. If the virus is challenged, then my lord, directly Supreme Court says you can directly into the High Court, my lord, because there is no such bar is mentioned. So if I read it, this 27.3 that specifically give empower me that I can file a writ petition directly to the High Court. In spite of that, if the tribunal is in function, then also I directly came to the High Court. 27. An alternative remedy by itself does not divest the High Court of its power under Article 226 of the Constitution in an appropriate case, though ordinarily a writ petition should not be entertained when an effective alternative remedy is provided by law. Here is not. When a right is created by a statute which itself prescribes the remedy or procedure for enforcing the right or liability, resort must be had to that particular statutory remedy before invoking the discretionary remedy under Article 226 of the Constitution. This rule of exhaustion of the statutory remedy is a rule of policy, convenience, and discretion. In case where there are disputed question of fact, the High Court may decide that decline the jurisdiction in writ petition. Here is not disputed fact, my lord, disputed law, my lord. However, if the High Court is objectively of the view that the nature of the controversy requires the exercise of its jurisdiction, such a view would not readily be interfered with. So, my lord, Magod Sugar is crystal clear. If virus is challenged, then if the tribunal is in function, then also a petitioner directly came to the High Court. There is no such bar, my lord. So the tribunal, in the case of if the virus is under challenge, the tribunal act as a supplement to jurisdiction. So a petitioner may directly came to the High Court if virus is under challenge. That's my respectful submission regarding the case.
Your Lordship may kindly have a look toward Article 323A once.
Constitution.
May I hand it over?
আমাদের বইগুলো এখানে হাতের কাছে রাখুন। Yes.
But first thing is, my lord, we are in this matter not concerned about any alternative remedy. We are concerned about the inefficacy, considering the situation, of the alternative institutional mechanism which was introduced by an amendment to the Constitution. This is the basic difference. We are not considering whether an excise authority is an appropriate appellate body or not, or any other statutory authority
Yes.
is an appellate provides an alternative remedy or not. Therefore, my lord, first, my lord, we need to understand, my lord, the subject matter. The subject matter in L. Chandra Kumar, which of course, my lord, has a reflection in this case also, is what was the basic consideration. Article 323A said that legislature is being empowered to enact laws which can inter alia curtail the jurisdiction of all courts except the Supreme Court. So therefore, the Parliament, by way of this amendment, conferred powers on the legislature to take away the jurisdiction of the High Court, amongst other courts. Please have a look toward 323A once. Administrative tribunals, Parliament may by law provide for the adjudication or trial by administrative tribunals of disputes and complaints with respect to recruitment, conditions of service, so and so, so and so, so and so, within the territory of India or under the control of the government of India or any corporation owned or controlled by the government. The law made under clause A, kindly take D. We are concerned about D here. Exclude the jurisdiction of all courts except the jurisdiction of the Supreme Court under Article 136 with respect to so and so. Therefore, what 323A did was, legislature was empowered inter alia to provide for an alternative institutional mechanism for discharge of judicial functions. This is very important, judicial functions. And in such process, the legislature can curtail even the judicial review power of the High Court, amongst others. Now, this fell for consideration. Now kindly come, Your Lordship may kindly come back to L. Chandra Kumar. But we need to understand the confines of L. Chandra Kumar as well. Please take me the first paragraph.
Yes.
So and so, then the issues are noted. Issue number 1 is whether the power conferred upon the Parliament or the state legislatures, as the case may be by subclause D of clause 2 of Article 323A or by subclause D clause 3 of 323B of Constitution to totally exclude the jurisdiction of all courts except that of the Supreme Court under Article 136 in respect of disputes and complaints with so and so with regard to so and so, runs counter to the power of judicial review conferred on the High Court under Article 226, 227 and Supreme Court under Article 32. The second question was what my learned friend is submitting right now, whether the tribunals constituted under 323A or B possess the competence to test the constitutional validity of such and such. Then 3 is, this is the alternative institutional mechanism, whether these tribunals as they are functioning at present can be said to be effective substitutes for the High Court in discharging powers of judicial review. If not, so and so. So this is the subject matter of consideration before the Honorable Supreme Court in L. Chandra Kumar. But I'll not trouble your Lordship by reading paragraphs after paragraphs. Now the purpose, please have a look to para 7 only. Why was this necessitated? Was because pendency. In pursuance of the powers conferred upon it by clause 1 of Article 323A, Parliament enacted Administrative Tribunals Act. The statement and object and reasons of the Act indicates that it was in express terms of Article 323A of Constitution and was being enacted because a large number of cases relating to service matters are pending before various courts. It was expected that the setting up of such administrative tribunals to deal exclusively with service matter would go a long way in not only reducing the burden of the various courts and thereby giving them more time to deal with other cases, so and so, so and so. So pendency in a particular category of cases was one of the causes which I would say, my lord, the Parliament wanted that it should be distributed amongst the tribunals. Then, my lord, skipping over a few paragraphs, my lord, may kindly take note, R.K. Jain was the first case where the Supreme Court flagged this issue, that today there is a need to estimate what is the effect of this tribunalization. R.K. Jain is discussed in paragraph. But please excuse me, just now since the judgment has been given to me. না 27 পরে আছে, অত পড়বো না বেকার। R.K. Jain paragraph 88, please come to 88. In R.K. Jain's case, this court had, in order to understand how the theory of alternative institutional mechanisms had functioned in practice, recommended that the LCI or similar expert body should conduct a survey of the functioning of these tribunals. It was hoped that such a study conducted after gauging the working of the tribunals over a sizable period of more than 5 years would provide an answer to the question posed by the critics of the theory. Unfortunately, we do not have the benefit of such a study, etc. Therefore, R.K. Jain was first to flag as to the efficacy of these tribunals. Then were the other quotations in that paragraph I skip over, may not be very important for us. Now kindly take note in this background what the Supreme Court says in paragraph 90. But we need not undertake this exercise as to the difference between providing an alternative institutional mechanism and an alternative remedy. I don't think that I need to waste your lordship's time on that. Now please take para 90. We may first address the issue of exclusion of the power of judicial review of the High Courts. We have already held that in respect of the power of judicial review, the jurisdiction of the High Court under 227 cannot wholly be excluded. It has been contended before us that the tribunals should not be allowed to adjudicate upon matters where the virus of legislation is questioned, and that they should restrict themselves to handling matters where constitutional issues are not raised. We cannot bring ourselves to agree with this proposition, as that may result in splitting up of proceeding and causing avoidable delay. So the court was conscious, court was addressed on the point that virus matters should not go before the tribunal. Supreme Court says no. They have the power, they have to be given that power, otherwise it cannot be a truncated adjudication of disputes that for few issues you go over there, for the other issues you come before the High Court, etc. Here again, my lord, the concept of, my lord, the bifurcation of the executive legislature and the judiciary would also come in. My learned friend has argued that because a virus is involved, therefore I need not, the alternative remedy does not stand as a bar. It is an exception carved out for alternative remedy. Because administration cannot, my lord, decide the virus of legislature. When I go before an administrative authority, how big authority he may be, he cannot question a legislative wisdom, a legislative competence. Therefore, my lord, an exception was carved out in the exercise of alternative remedy, which your lordships have held to be a self-imposed restriction. It's not that your lordships do not have the power. Your lordships have the power. Your lordships felt that no, each and every matter should not come before us. Something must be left to the authorities. Even after appreciating this, your lordships felt that these 3 or 4 exceptions should be carved out, so that in appropriate case, despite there being an alternative remedy, the court will still not be powerless to examine the issue. Therefore, my lord, I don't trouble you with the rest part of paragraph 90. Then we are from 91 onwards, everywhere your lordship would find that it is division bench, division bench, division bench, division. From 91 to I think 100. It ends at 100, but up to from 91 to 99, everywhere Millard, L. Chandra Kumar says that it must be a division bench. I had some weird argument made at one point of time because most of the high courts entertained writ petition in the division bench. Therefore, possibly keeping that in mind, L. Chandra Kumar had used this expression, the division bench. In our high court, it should be what my learned friend submits. I also unsuccessfully argued that at one point of time that it must come before, if there is a power of judicial, when the power of judicial review has been restored, it must be restored in the form it is available in high court. But I unsuccessfully argued this because when the Supreme Court restores the jurisdiction, it's not a creation of jurisdiction. Supreme Court restores the judicial review jurisdiction in spite of this alternative institutional mechanism. It must be followed in the words or in the fashion or in the procedure laid down by the Supreme Court. Otherwise, kindly not take me amiss, but otherwise, if today, Millard, people are allowed, but I'll take care of the situation in which my learned friends client are. But principally, legally, Millard, this submission I make right now. Therefore, Millard, once Millard, the High Court's power of judicial review is restored, I would be respectfully submitting that this restoration must be followed in the manner Supreme Court has directed. Therefore, L. Chandra Kumar, in my very humble submission, will not, Millard, allow my learned friend's client to come before a single judge of this court. Not that complicated.
What about losing one forum?
Yes, I'll come to that.
Not only that, the L. Chandra Kumar also lays down that it should go to the court of the first instance, the tribunal, and then to the High Court, so that the High Court has the benefit of the reasoned decision on merits. Here, there will be no reasoned decision because there is no judicial forum over there.
But two arguments. It is one thing to say that I am losing a forum, and it is another thing for the High Court to allow skipping a forum. Today, Millard, whether it is taken by a single judge or by the division bench, Millard, your lordships are only allowing the petitioner to skip a forum, skip the court of first instance. That your lordships are permitting. Why? For ends of justice. Simply because the tribunal is not functioning, that does not mean that the power to invoke the High Court's jurisdiction for judicial review will be lost or kept in abeyance till the tribunal starts functioning. Ordinarily, take an example, the tribunal is functioning. And my learned friend's client wants to challenge the virus of a statute. Millard, your lordships would ordinarily not, Millard, entertain, saying that why have you come over here? Go before the tribunal. At that stage, your lordship would not allow him to skip a forum. Tribunal is not an alternative remedy for them. Tribunal is the court of first instance where you are bound to go, except that exception if the tribunal act is challenged, Administrative Tribunals Act is challenged. Or say Article 323A validity is challenged. Or the creation cannot challenge the creator or adjudicate the powers of the creator. So, in my very humble submission, what my learned friend says is that I lose a forum. In my very humble submission, kindly do not take me amiss, is misplaced. Your lordships are permitting them to skip over a forum, because after this, the law was further developed by the Supreme Court by saying that these are the courts of first instance. Now comes the question of the reason for tribunal deciding this way or that way is not available before my lord today.
Before the division bench, it will not be available.
Yes.
The single judge didn't have the determination
Right.
had the
Right.
tribunal
Tribunal
malfunction.
function. Now, today, since the tribunal is not functioning, whether it is before the single judge or before the division bench, both the courts are robbed of this privilege of having the reasons of the tribunal.
No. If the single judge adjudicates an issue, then it goes to the division bench, and the division bench will have the decision. So it is the single judge's view that is there before the division bench. Single judge acts as the court of first instance in this case.
Therefore, my humble response would be that the single judge cannot relegate itself to that of a tribunal. A single judge is 226, a tribunal is 323A or B. Therefore, a single judge of the High Court exercising powers over here cannot relegate itself or cannot be invited to relegate itself only for the sake of reasons for the division bench to discharge powers akin to 323AB.
Yes.
Therefore, whichever forum he goes first, but this is not a case of loss of forum. But loss of forum, we usually argue in case of intra-court appeals. Because appeal is a vested right. It inheres with the institution of the proceeding. It gets triggered once an order is passed. Therefore, I would be very respectfully submitting, but I've forgotten that case. There is a judgment of the division bench of Justice presided over Justice Indira Banerjee, where a person had come directly before the division bench under article that 323AB category, alleging that the Tika controller did not have jurisdiction over the subject matter. Under 323B they came. There the question arose, very well, the Tika controller did not have power. Why don't you go before the tribunal first, get a judicial review, get it reviewed judicially and then invoke the power of the High Court. But there, my lord, these arguments which my learned friend is making was also one of the arguments made. And the division bench, and where I try to assist your lordship, this is with that cinema hall in our that Sialda area, Chobigar or something like that. Then we got this question, our division bench has held, if the appropriate authority does not have jurisdiction, you can skip over the tribunal jurisdiction and come before the division bench directly. It cuts both ways. If you say that he does not have jurisdiction, why waste your time before the tribunal? Come directly to the High Court before the division. But I'll assist your lordship with that. But I believe it is not a reported judgment, but I'll find it out for your lordship's consideration. Therefore, whichever way you look at it, the functioning of the tribunal being obstructed because of XYZ reason will not deny a right of judicial review to a aggrieved party, but whether before the single judge or before the division. My one-line argument is the power has been restored by the Supreme Court to a division bench. Therefore, you have to come before the division bench only. But I'll be very candid, Miller. L. Chandra Kumar did not consider this kind of a situation. That was not under consideration. But flowing from L. Chandra Kumar, but I think
There are other tribunals functioning throughout the country. Hasn't this occasion arisen earlier?
my lord, it has been, I'll tell you, Lordship, just it was during COVID period. I think it arose from a surface proceeding, if I'm not wrong, where the Supreme Court directed, of course, under 142, that so long the tribunals do not function, one must come before the High Court.
In a division bench or a single
That I have
bench?
to look up.
All
That
right.
I have to
But
look
then
up.
COVID situation was something different.
Different. I may be wrong, but just not since your lordship
All right, all right.
put this question. What I can right now recollect is it was some sort of a situation like this, where the tribunals were not functioning for some reason, maybe for COVID. Therefore, the Supreme Court says that so long the tribunals do not become operative, the High Court should exercise powers of.
And since when is this tribunal not functional? The judicial functioning is
the
not there.
judicial member or the chairman has retired, I think, in August 24, if I'm not wrong.
All right.
Not 20, no, Sumitra.
ও আচ্ছা হ্যাঁ ওটা 23
23.
23
23.
August 23. And the administrative member?
Last administrative member, I think, in September. Right?
This
September
25. Hmm.
2023 yes. এটা মনে আছে মান্থটা মনে আছে
September 25 হচ্ছে বাবা আর সুমিত্র পাল হচ্ছে তো
লাগে লাস্ট 23 তে আমাদের লাস্ট
হ্যাঁ সে তুই আমি কি করছিলাম না But permit me to come back on another day on that Supreme Court order which my lord was and Justice Indra Banerjee's order.
You also try to assist.
And whether this type of situation arose anywhere else?
I'll try to find that. I'll try to find it. I'll try to find it.
Because
But I'm inviting your lordship to
will
decide this. Please decide.
have
this.
a far-reaching
Yes, yes,
consequences also, and it won't end here. It's going to go up. Right? So all data should be there so that the court can at least formulate issues and thereafter decide upon it. Otherwise, half-hearted efforts
Yes, yes.
will go waste.
May I do one thing, Marat? Before that, kindly keep this matter after a week, Marat. I will, whatever judgment I do, because I go also few judgments, because of my lord wants to glimpses of the matter. What is the Supreme Court stand? Supreme Court consistent stand is that, my lord, they never, my lord, snatch away the judicial review power under Article 226, my lord, even before L. Chandra Kumar and after L. Chandra Kumar. In Magad Sugar, my lord, Supreme Court crystallized the 226 power, my lord, in regards of the alternative remedy, my lord.
No, you tell me one thing. Had the tribunal been functional, certainly you would not have approached the High Court. You would have gone there. So it is not that it's an alternative remedy or a supplemental remedy, nothing.
But kindly para 93 of L. Chandra Kumar, which specifically says the word supplementary.
It doesn't matter. Even then,
the tribunal power is the supplementary power to the High Court in the case of the virus is under challenge. Para 90 onwards, my lord, if I read it, my lord, para 90 is
assuming L. Chandra Kumar is there from 1997, not assuming, it is there. Even then, had the tribunal been functional, you would have gone there.
Yes,
admittedly.
I could gone there. But if suppose, my lord, but Magad Sugar says if the tribunal is functional, then also I directly came to the High Court.
All right. Even if you come to the High Court, then why not before the division bench and why before the single bench?
Single, because 226 is power is that the exercise, the para 20 of the Magad Sugar is very specific.
That is what the AG is submitting, that when the High Court is deciding an issue, it is under Article 226 or 227, not 323A and B.
Yes.
Have you followed?
Yes.
Whether that can be done.
My lord, it is done. Because of that, the Magad Sugar is very specific on that. But Magad Sugar says if the virus is under challenge, if the tribunal is in function, then also
Have you made out any case that the tribunal is not functional? That is the reason you have come here. Have you? Which paragraph have you made out that case?
my instruction is that no specific variance.
Milord, this question arose because, Milord, I had submitted, if you logically recollect, on the
It is
first
you
day,
who read the
because
took
he
this issue.
seeks to challenge a rule framed under Article 309. 309 has to be related to Article 310, which is for civil post. If it is civil post, he accepts that it is a civil post. Therefore, he
has
should
to go
ordinarily
there.
go over there. That was my
Right,
initial
right,
submission.
right.
Your Lordship was pleased to initially release the matter.
Yes,
Then
yes,
my learned
yes.
friend mentioned, and Your Lordship has been pleased to hear it once again.
Because of that.
No, definitely we are here to
Yes,
assist
yes.
Your Lordship.
And the Supreme Court stand is very specific on that. If the virus is under challenge, then the High Court can exercise its power under Article 226. If the High Court exercises its power under Article 226, then, my lord, the single bench can exercise its jurisdiction, my lord. The Mughal Sugar is very much clear about it.
All right. When
Very
do you
much clear.
when do you all want to come back again?
Kindly do not keep it this Monday. Any day thereafter.
Now the second SLST matters are consuming such a lot of time that other matters cannot be decided.
But please take it then, Milord, if possible, next Friday.
Friday, Friday, second of that would be the
No, I think Friday Your Lordship takes up those applications.
Thursday
Oh,
applications.
Thursday application. Thursday I can come.
Thursday applications, I will certainly not permit you.
Then Monday week in that case. Friday I have no difficulty. Possibly if my learned friend may have some problem.
no problem. পিছন থেকে ফোন করছি Friday.
15th I'm keeping it. It's a Friday.
Right.
It's Friday week.
16.
Heard submissions made on behalf of the petitioner and the state. List for further hearing on 16th of January. Take back this book. এটা আমাদের এটা ওনার আর এই বইয়ের র্যাকটা একটু কাছে নিয়ে এলে আমি হ্যাঁ এখানে নিয়ে আসবো আমি হাতে করে বই তুলবো আর এই লটে আর কিছু বাকি নেই
Shouldn't have been done today.
Shouldn't have been. Why?
Shouldn't have been done from?
কটা কোট ফাংশন করছে নষ্ট
I don't know why this court is functional every day. Even if there is 3:30, I have to sit till 4:30 or 5 or something.
You shouldn't.
I shouldn't,
No,
really.
these 3:30s are meant for the judges only.
I'll keep this in mind.
Because the amount of administrative work your lordships have to discharge after as you grow senior in the ranking, number of your administrative work increases.
Yes.